And I look forward to a weather report from most of you when I get a chance. But right now, let's get this meeting called to order. And Caitlin, if you will, read into the record the public disclaimer.
Okay. Notice of the February 16th, 2021 meeting of the Real Estate Commission, including date, time, and location, has been noticed on the Tennessee Real Estate website since August 26, 2020. Additionally, this month's agenda has been posted on the website since Friday, February 12th, 2021. Now for the roll. Commissioner Joe Begley. Commissioner Jeff Diaz.
Here.
Commissioner DJ Ferris.
Here.
Commissioner Steve Gwynn.
Here.
Commissioner John Moffitt. Commissioner Joan Smith.
Here.
Commissioner Stacy Torbett. Chairman John Grease.
Here. Get used to it.
You have a quorum.
I'm here too, Caitlin. I don't think you called my name.
Oh, you know what? I used last month's role, and you were out last month. Sorry about that. Vice Chair Marcia Frank.
I'm here. Thank you.
So Marcia, it sounds to me like once you miss a meeting, you're kind of dead to Caitlin.
No, for ease sake, I did remove her for all the roll call votes last time, but I'm adding you back.
I appreciate that. That's it, Marcia. Lead us in the invocation. Press the flag when this meeting started.
Okay, let's all pray. Dear Lord, we thank you for this day and for all the blessings in it. We thank you for the state of Tennessee, Lord, and we pray for our government workers, for our leaders. We thank you, God, for them. We pray today, especially, Lord, that everyone stays safe in this icy, cold weather. Please protect those without homes, especially today, Lord. We thank you for this time together at the Real Estate Commission, and we pray, Lord, that you will give us the discernment and the mercy and grace that we need to make good and just decisions today. In Jesus' name, amen. And we'll stand for the pledge, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Marcia.
Good job, Marcia.
Look at that, accolades. All right, back to Anna now. She'll read in the proposed statement of necessity, and I note that Joe Begley is now present and should be shown as present. And then we'll have to vote on whether you all believe the statement of necessity should be adopted. And if it is adopted, we can continue on with the meeting. If it's not adopted, we're done for the day. Ms. Matlock.
Thank you. This is an electronically scheduled meeting of the Tennessee Real Estate Commission. Notice of this meeting was posted to the Commission's website on Wednesday, August 26, 2020, and this month's agenda was posted Friday, February 12, 2021. As there is not a physical quorum present, a statement of necessity will be read into the record and filed with the Tennessee Secretary of State as required by statute. Pursuant to Tennessee Code Annotated Section 8-44-108B2, which states if a physical quorum is not present at the location of a meeting of a governing body, then in order for a quorum of members to participate by electronic or other means of communication, the governing body must make a determination that a necessity exists. That determination must include a recitation of the facts and circumstances on which it was based. Further, Tennessee Code Annotated Section 8-44-108A3 defines necessity as matters to be considered by the governing body at that meeting require timely action by the body, that physical presence by a quorum of the members is not practical, within the time period requiring action, and the participation by a quorum of members by electronic or other means of communication is necessary. As stated, this is a previously scheduled meeting of the Tennessee Real Estate Commission that is now being held via Cisco WebEx. The purpose of this meeting with members attending by Cisco WebEx is to conduct regular business of the Commission, including but not limited to the education report, executive director's report, and complaints. Furthermore, it is necessary for this meeting to be held electronically in accordance with Executive Order Number 16, issued by Governor Bill Lee on March 20th, 2020, further extended by Executive Order Number 71, issued on December 22nd, 2020, to ensure government continues to function openly and transparently during the COVID-19 emergency, while taking appropriate measures to protect the health and safety of citizens and government officials. Voting will be conducted by roll call.
Thank you, Anna. So, commissioners, if you believe that statement of necessity accurately reflects the situation we're in today, you'll vote yes when your name is called. If you don't, please vote no. Ms. Maxwell.
Commissioner Joe Begley,
Yes.
Commissioner Jeff Diaz,
Yes.
Commissioner DJ Ferris,
Yes.
Commissioner Marcia Franks,
Yes.
Commissioner Steve Glenn,
Yeah.
Commissioner John Moffitt,
Yes.
Commissioner Joan Smith,
Yes.
Chairman John Grease.
Yes. So the motion passes. We're clear to continue on with the meeting. At this point, we need to approve today's agenda. Please note that we've basically set the rulemaking hearing will follow the informal appearances. Are people here for the waiver as well? Caitlin,
I'm sorry, what's that?
the waiver request, are there people here for those waiver requests?
No, I will just be presenting those to the commission.
Okay, so let's put the rulemaking hearing following informal appearances. Now, other changes, additions, or corrections to the agenda?
Motion to approve the agenda as amended.
Thank you, Mr. Diaz. Is there a second?
Second.
Second, Joe Bagley. Discussion. When your name is called, if you're okay with the agenda as amended, you'll vote yes. If you're opposed, please vote no. Caitlin.
Okay. Commissioner Joe Begley,
Yes.
Commissioner Jeff Diaz,
Yes.
Commissioner DJ Ferris,
Yes.
Commissioner Marcia Franks,
Yes.
Commissioner Steve Glenn,
Yes.
Commissioner John Moffitt,
Yes.
Commissioner Joan Smith,
Yes.
Chairman John Grease.
Yes. So the agenda is adopted. Next, we need to approve last month's minutes.
Motion to approve the minutes.
Any corrections or additions? Motion by Mr. Diaz to approve. 40 seconds. I'm gonna give, I think Steve went veto on that one. Put Steve in as a second. All right, discussing any changes, amendments? Let's vote. When your name is called, if you vote to approve last month's minutes, you'll vote yes. If you're opposed, you'll vote no.
Okay, Commissioner Joe Begley,
Yes.
Commissioner Jeff Diaz,
Yes.
Commissioner DJ Ferris,
Yes.
Commissioner Marcia Franks,
Yes.
Commissioner Steve Glenn,
Yes.
Commissioner John Moffitt,
Yes.
Commissioner Joan Smith,
Yes.
Chairman John Grease.
Yes. All right, so those minutes are approved. Before we get to the informal appearance, I just want to do a quick weather check. I think I'll start with John Moffitt. How's the weather where you are, John?
It's about 70.
But no ice or snow anywhere?
No, I'm in Florida.
Congratulations. All right. Let's get on to the informal appearances. I'll check with other folks here as we go out to the meeting. I don't know who candidate A is, Ms. Maxwell. Can you help me? Now I do. You're supposed to.
Okay.
Casey Cunningham.
Yes, I'm sorry. Candidate A is Casey Cunningham.
Give us a little background.
Yes, I can. Okay. Mr. Cunningham has taken the Tennessee Real Estate Affiliate Broker exam. His principal broker, Meredith Lee Freeman, is with the firm Keller Williams Realty, Hendersonville. The summary of the criminal and disciplinary sanction is a misdemeanor theft of property, 500 or less. The statement and letter of recommendation can be found within your packets.
Okay, Mr. Cunningham and candidate B, who I still don't know either. Here's kind of the procedure. In each case, our executive director, Ms. Maxwell, will give us just a glimpse of what got you to this point, why you're in front of us today. We're going to turn the meeting over to each of you applicants, and you can tell us your story as much or as little as you want to. You can tell us what got you into trouble, what got you out of trouble, what you've been doing, what you hope to do, anything that you think might help us in our decision. Commissioners then will have a chance to ask you a question or two. Once we're through with the applicant, we're going to turn to your broker, proposed broker, and ask him or her why they are interested, why he or she is interested in having you associated with her firm or his firm. So that's the procedure. Casey Cunningham, you get to go first. Tell us what happened and what you think we need to know.
Well, good morning, everybody. Just real quick, John, can you hear me okay before I begin?
Well. Yes.
Okay. Well, what happened to me, I'm pretty open and honest about my situation. I was at the time struggling with addiction, and since then have done everything in my power to change my life. And really what has happened is, you know, it's just a testament to God where I'm sitting today and where I was in the past. I don't believe there's really anybody that can sit there and never say they sincerely regret a certain decision, but I believe it's, and I really do regret it, but I think that that decision of mine doesn't define who I am. It's how I learn and grow from it is how it defines who I am. And I do that on a daily basis. I've been sober going on a couple years now, and I do things daily to participate in growth and spiritual wellness. And I just want to move forward and become a better person. And I found this opportunity to try a new career. And, you know, I just want to go through the proper avenues in order to try to change that. But I really do believe that my story is not unique in any shape or fashion, but I just think it's a testament of what God does for me, what I can't do for myself. And I know that even if this doesn't go the way that I may want it to, that things are going to be okay, because it's just the way it works out that way. But yeah, it's been an interesting journey, but I'm very open about it, and I'm fully open to any questions that you all might have. And if there's anything that I might need to clarify with you all, just feel free to ask, and I'll be here to answer them.
Okay, commissioners, questions? Ms. Franks. Unmute yourself, Marcia.
Okay, there it goes. So could you tell us about the circumstances of your crime?
Yeah, I was addicted to a substance and in desperate need of it. I'm not sure how familiar you all are with drug addiction, but when you are addicted to something, you kind of throw all morality out the window, to be quite frank. And I had an opportunity at the time, which was to break the law and steal some money in order to get what I needed at that time. And those are the complete circumstances surrounding it. I was working in a situation where I had a key to my working place, and I went in there and took the money, and I admit to that, and got exactly what I needed, and paid the consequences for it later, but I still believe it was a turning point in my life. Yeah.
And so tell me about, when were you the director of the Davidson County Recovery Court?
Well, as a direct result of the situation that we're talking about, I actually participated in the treatment court recovery program in Davidson County and got to know the counselors. And at the time, it was Judge Casey Moreland. He's no longer there. I don't know if you guys remember what happened there, but at the time it was through him. And when I graduated that program, I was actually approached by Nan Casey and Judge Moreland to start a career in counseling and start working for the exact same court that I was formerly charged in. And I did that up until that situation arose with Judge Moreland and Nan. And as a result of that situation, Judge Robinson came in and they promoted me to the acting director for a minute because I was the only one really that knew the treatment side and the law side. So I did that for a little bit and then resigned my position at that place because it was starting to affect my own recovery. It was just a little bit difficult for me to be a counselor and then work on the court side because I was forced to make objective decisions based on my subjective feelings, but I just decided to move on with a different career.
So how long were you the director of the recovery court?
The acting director for about 4 to 6 months, but I was working there for like 3 years.
Okay, and so what are you doing now?
As of now, I've been working at the office at Keller Williams in Hendersonville, kind of like agent concierge, helping out the team out there, answering questions, helping not Meredith, but helping Beth with commission checks and disbursements and all that.
So what do you do as far as the commission checks and disbursements?
Well, I just go on to Winmore. I like anytime there's a title company that sends in closing docs with the commission check, I go in and scan it to our director of finance. And then I go into the computer and it's a program called Winmore, and that goes ahead and disperses it. I don't actually physically take the money and give it to people. I just do it on a computer system and stuff like that.
Okay, that's all I have, Mr. Chairman.
Joe, I'm sorry.
So I have a question. This letter that you wrote, it says that this happened in, where'd he go? This happened in 2015. Is that correct?
Yes, it did.
And then it says something about it happened again in February 2020. Is that correct?
I'd have to see the letter. Kyle Walker wrote it for me.
I think this is you writing this letter. Is it, Caitlin? To whom it may concern? Did you write a letter that said I wanted to take a few minutes and address a few things in regards to my criminal background?
Yeah.
You did write that letter.
Yeah.
Okay.
The cover letter. I'm sorry. I thought you were talking about Kyle Walker's letter.
No. About halfway down, it says, have since sought a new field and want to extend the record. COVID. I also currently have a pending case back from February 2020 dealing with the same kind of issue. Was that, so did you do the same thing twice?
Yeah. The problem with that, though, is that it's been dismissed, but we don't have an actual situation that, with COVID going on, they've dismissed everything, but I can't go on there and tell them, I can't go to the court clerk and have the thing dismissed because of COVID.
I guess my question is, did you take money in 15 and 20 or?
Just 15.
You only took money in 15?
Yes, that's correct.
Okay. Thank you.
Other commissioners? All right, Ms. Freeman, it's your turn to give us an idea of why you're interested in having Mr. Cunningham affiliated with your company.
Hi, good morning, everyone. Casey Cunningham came to us, and since then he's worked with us in our office, helping staff and customers alike. And I understand that there was a question concerning the handling of money. We do have a finance director who handles that. He's more in charge of entering the data, the information that allows her to process the checks and disperse it to the agents. And so just to kind of address that. But since he's come to our company, he's kind of our director of first impressions at our first desk. He's definitely made an impression on our agents and the customers that come through. We see that he's on a path towards growth as far as where he's been working, as far as the things that he's done outside of his office, outside of the office with us. He's really shown that he's working towards that recovery, we feel. We just wanted to give him an opportunity to have a career in real estate if that's what his next step is to be. I do feel that our office offers a lot of training and guidance and mentorship, and that's something I know that a lot of new agents need. And I feel that we would be there to be able to help him with that education and with that growth that he's seeking, as well as provide that guiding hand. I don't know about all real estate companies, but ours has a coach that helps the agents with their first several transactions, kind of handholds them directly with that. And so he'd be participating in that coaching program. And along with myself and my team leader who have worked with him directly to know that he's on that path and willing to make that education commitment, and he's coachable. So.
Thank you, Meredith. Are there questions for Ms. Freeman? Marcia.
Good morning, Ms. Freeman. Could you tell me, so you've known Mr. Cunningham for how long?
In about 6 months. Casey, is it about 6 months?
That sounds about right, Meredith. Yeah.
Okay, and so Ms. Freeman, could you tell me what was the other thing that happened in February of 2020?
I'm not aware there was another incident that happened in 2020. I do know that it was addressed in the letter, but I believe it was something that he had to go back to court for. I don't know, Casey may be able to further it. It wasn't something that happened while he was with us, however, so I guess I'm not clear then as far as what that February 2020 incident would have been.
Okay, and can you tell me who Kyle Walker is? You said Kyle Walker wrote the letter?
He's an attorney. Are you talking to me? I'm sorry.
I was talking to Ms. Freeman.
Okay.
I do not know a Kyle Walker. He's not affiliated with our firm.
Okay. That's all I have for Ms. Freeman, Mr. Chairman.
Would you like to go back to Mr. Cunningham with those two questions?
If I may. So, Mr. Cunningham, so can you tell us what was the charge in February of 2020?
As of right now, it's an open case, which comes back to a felony theft charge. But I didn't know if I needed to put it on the docket because I haven't been convicted of it, and I'm not going to be, which is what that letter from Kyle was stating. It was just an interesting situation that got brought up from a slip-up I had a little over a year ago. But the fact of the matter is that I knew everybody there, and they said they would dismiss everything, and that's Kyle's letter saying the same thing, but we just haven't gotten to the point with the dismissal yet. But he wanted to show that him and Judge Robinson and everybody else was going to show that they would be dismissing the charge if they needed to.
So I need you to tell us what is the charge. You said felony theft?
Yeah.
And can you tell me something about that charge then?
Yeah, I'm sorry.
Not that it's going to be dismissed, but what happened?
I had relapsed a little over a year ago, and I got to somebody's car who I knew, but they weren't happy at me at the time, and they called the police, and it ended up being a charge for theft, but it's not going to end up being a conviction, is what I'm trying to say.
So you took a car without permission?
Well, a little bit. It was a friend of mine who I knew, who we were kind of riding around together, who he'd gotten into an argument about, and yeah, that's pretty much what happened.
So the charge is theft. You stole a car is what they're charging you with?
That's what the charge is, yes, but that's not going to be the conviction, and that's what that letter.
Have you been to court yet?
Yeah, I went over a year ago, and they were just making it. They put me in a situation to where I was going to see how I would do for a year, and then they were going to dismiss the charges since I'm doing what I'm supposed to be doing for over a year now. That's what that letter from Kyle Walker And if I need to produce a letter from the district attorney and the judge, I will. But that's what that letter is stating, is that all of these will be dismissed, as if it never happened.
Okay, well, that's a little worrisome to me that it was just a year ago that you relapsed and then you took a car, regardless of the circumstances of the case. And so when was the 1 year up that when they'll come back and discuss it again?
I believe at the beginning of March 3rd or 4th, whichever is the first Wednesday of March.
Okay, so that hearing has been set?
Yeah.
Okay, that's all I have, Mr. Chairman.
Thank you, Marcia. Other questions for either Ms. Freeman or Mr. Cunningham? Joe?
I just wanted to.
Who said that? Caitlin?
That's Caitlin, yes. Yeah, I was just going to quickly say that as the commission, you should only look at charges that they've been convicted of. The statute requires that any licensee that is convicted, once licensed, report that within 60 days, and then it gets represented to the commission. So I just wanted to note that it would be best to only look at charges that Mr. Cunningham has actually been convicted of at this time.
All right, thank you, Caitlin. Joe?
I think I'm okay.
Okay. All right, other questions for either the broker or the applicant? If not, the chair is ready for a motion. By the way, Mr. Cunningham and candidate B, he'll take five votes out of 8 people voting to get you moving along the process or to get you out of the process. Commissioners, this is a motion. Jeff?
Motion to approve this candidate.
Thank you. Is there a second? Steve Gwynn seconds the motion. So on the floor now is a motion that, if passed, would allow Mr. Cunningham to proceed to get his real estate license. Is there discussion before we vote? I sense we're ready to vote. If you're in favor of the motion, when your name is called, please vote aye. If you're opposed, vote no. Caitlin?
Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Commissioner Marcia Frank,
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffitt,
Aye.
Commissioner Joan Smith,
Aye.
Chairman John Grease.
Yes. All right, Mr. Cunningham, as the director of First Impressions, you did pretty good today.
And thank you. And just to let you know, John, it's about 25 degrees outside my window.
Well, we're not through with you just yet.
Oh, okay.
Here's the deal. You've got a lot to prove to yourself and to your community, and especially to your broker who's taking a chance to go out on the limb with you. So make her proud, make yourself proud. I think you'll do it. Is there snow on the ground there too, Casey?
Absolutely, there is.
Where are you? Where are you?
I'm in East Nashville.
What do you have there? Snow and ice?
Yeah, it's weird. It didn't feel like snow. It just seemed like a bunch of ice on the ground, like a big snow cone.
All right. Well, get to work, will you?
All right. And at this point, do I just go forward and put the application in as a normal applicant would, minus that criminal background check thing, or how does that work at this point?
Aaron, are you listening in?
I can speak to that as well. Yes, you can go ahead and apply normally, and then if you will just reach out to, do you have Aaron Smith's contact?
I do.
You will just reach out to Aaron when you do apply, and we can add today's meeting minutes or approval to your application.
Okay, great. Thank you so much.
So, Casey, you, Ms. Freeman, are welcome to stay for the rest of the day. Or you might think there are more important things you need to be doing, and you can sign off right now. You're done. We're done with you all.
Okay.
Good
Well,
luck.
thank you so much, y'all.
All right, next up is candidate. Who are we talking about, Caitlin?
We have candidate Doris Walling.
I see her.
I think you might be on mute still.
No?
I think I see Doris, but we can't hear you.
I've just unmuted.
Okay, thank you.
And who's her proposed broker?
Ms. Freeman is also here with.
So, Doris, is it Ard Walling? Is that how we say your name?
Yes, sir. My last name is hyphenated. It is Ard Walling. I will answer to Doris, but I usually go by Teresa.
Go by what?
Teresa, my middle name.
Got it. All right, Caitlin, give us a little background.
Okay. Before you have Teresa. She has taken the real estate affiliate broker exam. A summary, her broker is also Meredith Freeman with Keller Williams Realty, Hendersonville. A summary of the criminal and disciplinary sanction is a misdemeanor attempted exploitation. Her statement and a letter of recommendation can be found in your packet.
Okay, thank you, Caitlin. So, Teresa, you've seen how this works. So
Yes,
you have the floor. Would you tilt the computer screen a little bit down towards you just a little bit? There we go.
that
Would
good?
you
Okay.
tell us everything you want us to know about the event that got you here, what you're doing, what you've been doing, what you'd like to do, anything you think is helpful to your case?
Okay. I'm having to hold my phone because my computer would not connect this morning. So if it moves and I need to readjust, please let me know. I have, I became friends with an elderly lady, and it was just a chance meeting, but she was struggling to get her groceries in over a double ramp that she had at her house. So I stopped to assist. We had a friendship that grew from there. She was very loving and sweet, very elderly lady. And I told her if she needed help to give me a call. Well, that opened the door and I began helping her quite a bit. And unfortunately, and this is no fault of her own, but she had a UTI and became confused. And during that confusion, she made a couple of statements that ended up with me being charged. However, during that statement, or during the process, and I think I have letters in my file, she had come back and said that she did everything for me and my family of a free will. She often gave me money. We would argue over it. And she got to where she would tell me, look, I want to bless you because you're a blessing to me and I could not survive without your help. And so she did bless me. And, you know, I was there to help her anytime she called. During the court case, they wanted to kind of pick and choose what they would use from what she said. It is documented that she made the comment, like I said, that she wanted to do what she did. She would not have survived without my help. I'm not exactly sure how that is, but I did help her a lot. I checked in on her a lot. It was an unfortunate circumstance that happened. Fortunately, you know, it only ended up being a misdemeanor. I volunteered and paid restitution on the final day of court to all the gifts and blessings, as she called them, to me and my family. I was 60 when I was charged. I'll be 62 in a few months. Never been in trouble, never plan on being in trouble. Since then, I did lose my job. I was a physical therapist assistant at Skyline. I had been there for 21, 22 years. Lost my job there. Since then, I have delivered pizza. I have worked for Instacart, which I am still doing, except on days like today and yesterday. It's not too safe, but I'm doing anything I can to take care of my life and my family and pay the bills that I can. I was never one that wanted to sit around. I always felt that even whenever it was time for me to retire, I needed to find something to do, because I'm a firm believer on you need to keep moving, to keep going and using life as God's given you. Also in that time frame, I am an associate pastor of my church. I am over a group of youth, and I have 9 now on my youth team that I'm a mentor to and I check up on and keep tabs with. And I'm very active in that. I just want to get my life back. It was really a knockdown, and it made me second guess everything that I had done. Sorry. But I enjoy helping people, and this is another avenue where I can help people reach their dreams and reach their goals. And it's something that I can do when I'm 70 and 75. So I'm open to any questions.
Okay, commissioners. Marcia.
So, Ms. Walling, can you tell us a little bit more about how the charges came about? Who charged you? And then also, can you tell us a little bit about the $24,000, please?
I have no idea who brought the charges against me. I received a phone call from an investigator and said that she wanted to talk to me. I had gone on vacation. I'll back up. I had gone on vacation in October of 19. My friend called the ambulance and went to the hospital. When I came home, she had been placed in the skilled unit. I went and took her mail and personal belongings and everything that she needed to get her set up. They wouldn't tell me who filed the charges. All I know is it was state versus me. The investigator said that my friend had stated that I took the money, and this was during her time of confusion. And then she later said that she did everything she wanted to. My friend was very, very kind, and like I said, I need work. I get work. I knew and helped her for over a 2-year period. Part of that is my son had vehicle difficulty, and she wanted us to do some work and clean out some buildings on her property, and she gave him money for a new vehicle because she was using me a lot, and my son wasn't having a vehicle, so she gave him money to buy him a new vehicle. She wanted to give him more, but we wouldn't take anymore because all he needed was a used one to get around. And so that's where a lump sum of that came from. And as I said, I did volunteer to make restitution. I cleaned out my retirement plan to make that restitution because I didn't want her to do without. And if I had known things, well, I don't know. I started to say if I'd known things were the way they were, it might have been different. But I don't know because she was very quick up until her DTI that she had.
That's all I have.
Joe.
So when you were on the money, were they checks that were written, or were they was it cash, or how were you getting the money?
She would write out checks to me.
So at that time, was she in a conservatorship? Was someone her conservator at that time? Because it says your restitution was to be paid to the conservatorship.
During the court, they appointed a conservatorship. But no, she was living alone and paying her bills, and I would do her shopping for her.
So the court is a pretty big deal. So the court must have deemed her unable to make decisions for herself during the trial, I guess, because they decided to make.
It was,
Huh?
I'm sorry, I did not mean to interrupt.
Oh,
It
that's okay.
was during the trial. We had actually, in February of the same year, February or March, I'm not real sure on the date, I had taken her to see her attorney and she had changed some things in her will. Now, on her will, not only did her attorney sign it, but it was witnessed by the district attorney in Sumner County. In October, I took her back because she only had a niece and she was concerned of what the niece would do with the money. And she had talked to the lawyer about me being the trustee if anything happened to her so that I could make sure her niece was taken care of. That will never did get finalized because I took her right before I went on vacation. So she got sick while I was on vacation and we never made it back to the attorney's office. So they were able to prove at least up until a few months, and that she was cognizant because the DA had signed her will. And the DA had a discussion with her and with me in October, in fact, right before the charges. But during the court is when she got a conservatorship.
You know who the conservator was?
It was an attorney, a court-appointed attorney, and I cannot remember his name. He was out of Sumner County.
So when she was paying you, did you feel like she was mentally in pretty good shape?
Yes, I did, because she could give me a shopping list and tell me to the penny what it would be. She could tell me what she saw on TV that day, and I could verify it because working in a hospital setting, a lot of times I was in a patient's room and they would be watching the same TV. She could keep me up to date on the weather. She would call and tell me, hey, it's going to get really cold tonight. You need to make sure you're warm enough. And, she was kind of being a mother hen to me and everything. But no, she was very cognitive and very with it. I used to tell people that she was sharp as a tack because she was up until the point of the infection that put her in the hospital.
Thank you.
You're welcome.
Steve,
Yes, thanks. On the 24,000, how long did it take to, let's say, transfer the money from her to you? Was it over a period of months? Was it a one-shot deal? Was it, how did the 24,000 come about? Meaning, how did you get your hands on the 20,000? And then I guess the second question would be, did you ever look at her bank statements, or were you aware of how much money she had at any point? Just out of curiosity, was the 24,000 a lot of her net worth, if you will, or was it a small percentage, or do you know?
I really don't know. I was under the impression that it was a small percentage because she had 2 lock boxes and a bag full of money in her house because she didn't trust the banks, and it was well hidden. I knew where it was. And she had multiple hiding places for her money. Now, she's in her 80s. She's lived through the Depression. She had been very cautious with her money and what she made. A lot of times I'd go and she'd be balancing her checkbook. And so I did not feel that I had any need to ask her, hey, how much money do you have in the bank?
But the 24,000, was it over a period of 6 months, or how long a period of time was it over?
She gave my son the money to buy a vehicle, so that was $15,000 that she gave him. And the other money was over the period of time that I knew her.
Year or
and
months?
Well, I worked with her for about I helped her out for about 2 years.
Okay, thank you.
You're welcome.
Other questions?
Ms. Doris,
Yes, sir.
DJ?
DJ here. Thank you for your time with us today. Did you ever meet any of this lady's family?
I met the one niece that she was leaving everything to, and the niece's father. The niece was disabled, and she lived with her at that time, he was 92-year-old father that took care of him.
Okay, thank you.
You're welcome.
Trey said that, back to who brought the charges. Sounds like maybe the niece might have been the one.
I have no clue, because when I asked who brought the charges, they would not tell me. They just said the state is handling this. Now, and I saw the niece very often, probably about once a week, because my friend would buy groceries for them and ask me to take it to them. And sometimes they lived close to the hospital that I worked in. And sometimes she would give me envelopes of money and say, take this to them. So I would see the niece and her brother-in-law often.
John, I would say, and what I'm thinking probably happened is with elderly person, just like a child, if anyone even suspects any kind of exploitation or harm to those people, that the state themselves can bring up their own charges for it. So probably when she went to the hospital, if they asked her a question or something and she might not have been in her mind at that time, the state would have said, call the DA's office. So that's what I'm thinking probably happened. I don't know, but I know that that's a huge possibility.
And I'm sorry, may I interject?
Yes, please.
One of the things that my lawyer told me is that they had just started the new, the elderly abuse at the end of 2019, and they were looking to make cases. And he actually warned me before we went to court and said that most likely they would want to use me as an example. But fortunately, it turned out better than what we first started out with.
Any other questions for Ms. Hardwalling? All right, Ms. Freeman, back to you. Have you learned anything this morning you didn't already know?
I had talked with Teresa. She contacted us at the beginning of the year. So we spoke first, and then she also interviewed with our team leader. So she was very clear and it communicated everything at that time. And so I think we had a pretty good understanding of her case and what had happened. And since then, we've been in contact with her. She's really wanting to grow a new career. From her dedication to her previous career, we see that she is committed and loyal, coachable. Once again, we have programs in place to guide her, and we felt that she would be open to that and open to learning. She just wants to get back to helping people. And our company is, and in real estate, we help a lot of people. And I did want to point out to the commission, in our office, we are not an office that collects any type of earnest money this time. And so I don't know if that's of any consideration. We don't money made out to our brokerage for an escrow account or anything. So I don't know if that's of any consideration. But just wanted to get back to the fact that Teresa came to us, was very open, honest, and we just want to be able to help her in any way that we can, if given the opportunity for her to pursue her real estate career.
All right, commissioners, questions for Ms. Freeman? If not, is there a motion?
I'd like to make a motion that we approve Ms. Walling.
Second.
Okay, the motion is made by Ms. Franks and seconded by Mr. Diaz. If passed, would allow Ms. Teresa Hardwalling to pursue her real estate license. Any discussion on the motion? All right, if you're in favor of the motion, when your name is called, please vote yes. If you're opposed, vote no. It'll take five aye votes, Teresa, for you to be able to move forward. Caitlin.
Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Yes.
Commissioner DJ Ferris,
Yes.
Commissioner Marsha Frank,
Yes.
Commissioner Steve Flynn,
Yes.
Commissioner John Moffett,
Yes.
Commissioner Joan Smith,
Joan, you're muted.
Yes.
Chairman John Grease.
Yes. All right. Miss Teresa, do good.
Oh, I will. Thank you very much. I appreciate this opportunity.
And don't always remember your broker took a chance on you. So make her proud as well.
Oh,
Thank you.
she
Mary.
will be. She will be. Thank you.
You all are welcome to stay the rest of the day if you want to. Or you can get the heck off this TV and get to work.
Thank you, commissioners.
Okay.
Thank you, everyone. Thank you.
Bye-bye.
Quick question, since I have applied for my license and I've paid all my fees and everything, I'm just in the waiting for my number, correct?
Correct. Yes, we will review the application and let you know if anything else is needed. But otherwise, thank
All
you.
right. Thank you. Y'all have a good day.
You too. Okay, we're now to rulemaking, but before we get there, I noticed that Mark Green has joined our panel here. How's the weather? Where are you, Mark?
Mr. Chairman, I'm in lovely Marshall County in Chapel Hill. We got no snow, but we have about 2 inches of ice, so it's one big ice cube. But we're warm and doing okay, and hope everybody is not frozen under either.
Are you here for any particular reason, or just to watch a model commission operate?
I had been trying to make a habit to join you regularly to watch a model commission operate, and so I'm not here for any other particular reason than to be here for the offering of any guidance or anything that might be needed from me.
We appreciate it. Does your office regulate the new gambling board?
No.
Just checking.
I believe that falls under the Secretary of State's office.
Okay, just checking, because we might need some advice if you did have that. We're going to go to rulemaking hearing. This is all according to a script, right? Assuming there's not anybody here to talk about it.
I don't know if we have any public comment yet from individuals present, but right now it's going to be a lot of talking from me, so please bear with me while I get through this.
How long do you think it will take?
I am not giving time estimates anymore after our previous hearing, so hopefully not very long.
So should we take a break real quick and then come back for you to do that?
That's fine. We can take a break and then come back.
Let's just do 5 minutes or so. Let's come back at 25 till. Oh, no, that's not right. Let's come back at 9:30 or 10:30, depending on where you are. Okay, and it's 1/2 the hour. If you want to get started with your work, we'll pay attention.
All right. As I was saying before, this rulemaking hearing is going to contain a lot of reading, so please bear with me. This rulemaking hearing is called to order. My name is Anna Matlock. I serve as an associate general counsel in the Tennessee Department of Commerce and Insurance, Division of Regulatory Boards, and I represent the Tennessee Real Estate Commission. Would the agency representatives who are present today introduce themselves for the record? We'll begin with Ms. Maxwell.
So you want to get the commissioners first, Anna?
Sure, that's fine. If you will just go ahead and state your name for the record, please.
John Grace.
Jeff Diaz.
Joan Smith.
Steve Quinn.
Marsha Frank.
John Murphy.
Shall we get other staff? You want Mark Green to introduce himself since he's on this call?
No, I will just make a note that I believe that Commissioner Joe Begley will also be joining us shortly, and Ms. Caitlin Maxwell is here as the Executive Director.
Okay.
I'll go ahead and continue. Today is Tuesday, February 16th, 2021. This rulemaking hearing is taking place pursuant to Tennessee Code Annotated Section 4-5-204 via Cisco WebEx video conference platform. The purpose of this rulemaking hearing is to solicit comments on one set of the rule amendments to the rules and regulations of the Tennessee Real Estate Commission. The proposed rules are in response to the enactment of the Fresh Start Act, or Tennessee Code Annotated Section 62-76-101, that became effective on July 1st, 2018. The rule removes the previous requirement that prevented individuals from convicted of any felony or a misdemeanor involving theft of money, services, or property from eligibility for the examination or licensure unless 2 years from the date of expiration of probation, parole, or conviction, or the date of release from incarceration, whichever is later in time. Furthermore, the rule narrows the individuals required to appear before the Commission for licensure consideration due to a criminal conviction. Currently, the rules requires all individuals convicted of any felony to appear before the Commission. To comport with the Fresh Start Act, this requirement is narrowed to all felonies enumerated in Tennessee Code Annotated Section 62-76-104B4B and felonies involving the theft of money, services, or property. Pursuant to the Act, these felony classes have a rebuttable presumption that the conviction relates directly to the fitness of the applicant engaged in the applicable occupation, profession, business, or trade. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or describes the procedures or practice requirements of the agency. Proposed rules are filed with the Office of the Secretary of State. Notice is given to the public for comment, and a rulemaking hearing is held. Upon conclusion of the hearing and adoption of the proposed rules, the rules are forwarded to the Attorney General's office for review of legality. If approved, they are filed with the Secretary of State, which is responsible for publication, and the Government Operations Committee of the General Assembly. The rules must stay in the Secretary of State's office for 90 days, then end of which time will be the effective date. Those members of the public wishing to speak should place their name in the chat box located in the bottom right-hand corner. Only those who have entered their name will be permitted to speak. Oral comments will not be accepted from persons who have not entered their name in the chat box. Is there anyone else that desires to offer oral comments but is only appearing by phone and cannot access the chat box? Seeing that there are none, I would call your attention to the chat box. If you go to the link that is placed there, you will see a copy of these rules. The notice of rulemaking hearing included the entire text of the proposed rules and were published on the Tennessee Administrative Register website on December 23rd, 2020. Ms. Maxwell, what additional notice was given to the affected individuals or groups?
Unmute.
This is sent out via Notify and also noticed on the website.
Thank you. As the agency hears public comment on the proposed rules, I, as moderator, reserve the right to limit such comments if they become repetitive, so please limit your comments accordingly. I will now summarize the substance of the proposed rules into the record. The proposed rules are amending Chapter 1260-01, licensing, specifically 1260-01-.014. That paragraph is removed and deleted. Section number 4, the first provision stating notwithstanding the provisions of paragraph 4 of this rule is removed, as this paragraph has been deleted. Also, paragraph 6 is now renumbered to paragraph 5, and it's if within the past 10 years an applicant has been convicted of or pled nolo contendere or guilty to any felony offense enumerated in TCA section 62-76-104 or a felony and or misdemeanor involving the theft of services, money, or property, or had any disciplinary sanctions imposed on them by the local, state, or federal occupational licensing body. Also, section 5, the information in subparagraph B1 is amended to include offenses enumerated in TCA section 62-76-104 B4B and or felony or misdemeanor. Also, a new subsection D is created, which states an applicant who appears before the commission requesting licensure and who is denied will not be eligible for reconsideration for 6 months from the date of denial. We will now move on to the comment period of the hearing. At this moment, I have not received any public comments from emails or otherwise. However, comments were previously provided at the November 12th, 2020 rulemaking hearing will be incorporated on the rulemaking hearing filing form, and I will read those comments into the record. The first comment is from Mr. Guy Ritchie. It states, I would have preferred to share my opinion in the public at the board meeting, but unfortunately I will be out of town on April 8th. That being said, I'm thankful for this avenue which to communicate here with you. Here are my thoughts. Someone that pleads guilty to or is convicted of a felony is sentenced to punishment by a court. Unless I'm mistaken, those sentences generally consist of incarceration, fines, penalties, community service, or some combination of such. If the court wanted an individual to also lose the ability to become gainfully employed for some period of time, that too should have been included in their sentence, spelled out and defined. Otherwise, their sentence isn't really their punishment, but rather just a part of their punishment with another component that cannot be fully known or defined hanging over them from an indeterminate period. I believe that once a person has served their sentence and paid their debt to society, they should be wholly restored as a citizen, period. It's generally known that recidivism rates are lower amongst people who are employed and able to work for themselves compared to those who cannot. Truth be told, there is no way to know if someone is rehabilitated or not, and there never will be. But it certainly should not be within the purview of the group of realtors, random government employees, or business owners, etc., to make such a determination. Those people are comprehensively unqualified to do so. I believe if a person has done their time and passed all the exams and requirements as the rest of us, that person should be granted a license just the same. If the intent is truly to give someone a fresh start, then let's remove the obstacles and let them get on with it. Thank you for your time. Previously, the commission had no comment for this comment submitted. Is there any comment today?
So Anna, was that person speaking for or against the rule change?
Based upon my reading and interpretation, it's for the rule change. They're in favor of it.
Thank you.
Okay. I don't see there's any additional comment. I'll move to the second one. It's from Ms. Kim Young. It states, to whom it may concern, I would like to voice my opinions on this hearing. I'm a former probation officer and have worked in the court system with a criminal justice degree. No to the Fresh Start program. We are professionals in the real estate industry. It would be like lawyers letting criminals have a fresh start in their law offices. We are subject to laws, rules, and regulations. These folks should be allowed back to school to get degrees and then have a fresh start. Seems to me that this is easy access with a limited amount of effort for former criminals to have access to homes and private property. Most of these folks have friends in the criminal justice system. This is not a good idea. Previously, the commission had no comment for this, no response for this comment. Is there any comment today?
So to be clear, you believe this person was speaking against rule change?
Yes, it
Thanks.
would be my understanding, yes. Okay, seeing that there are none, I'll move to the third comment from Ms. Diane Farr. It states, I totally understand giving someone a fresh start. However,
Anna?
not when it, yes?
Anna, I'm sorry to interrupt you. This is Mark. I think Commissioner Franks had a comment.
Okay, sure, sorry.
Say. Okay, something's happening to my audio.
Marcia, it appears that you're logged in twice.
How do I log out again?
Can you close out of the link and then come back?
Yes, I will.
Okay, looks like you're on here once now. But you're muted. Okay.
Sorry. So I'm wondering, are all of these comments, are they anonymous, or do we know who made the comments?
No, the comments are not anonymous. I have the names of the individuals that sent them to me via email.
Okay, thank you.
Yes, Mr. Beckley.
I think I've been a little bit confused. So with the Fresh Start program, can we still keep the rules as they were?
So the rules as written are overly broad. So the rules include all felonies instead of felonies that it's going to be amended to felonies that are directly related to the program. So that would be any felonies related to theft of money, services, or property. And also there are certain felonies that are listed in the Fresh Start Act that have a rebuttable presumption. Mostly those felonies are considered Class A, B, or C felonies, and or any individual that has a conviction that has placed them on the Animal Abuse Registry or the Sex Offender Registry. So those individuals would still be required to appear before the commission. So essentially it's removing individuals that have any D or E felonies that are not related to theft of money, services, or property. Typically those are lower level drug offenses. And also, but it does not amend the misdemeanor section. It's only amending the felony section. Do you have any other questions?
So just to be clear, this is going to take the D and E felonies and let them come in without coming to the commission. And you're saying typically the D and E felonies are not money related, theft related, animal abuse related, sex offender related.
Right. So my understanding of the Fresh Start Act is it's designed to allow individuals that have received certain convictions regarding drug offenses or lower level offenses that have opportunity to obtain occupational licensing. So as you will see, if, for example, if an individual with a Class D felony for manufacturing of some kind of drug was to appear, that individual would no longer have to appear before the commission. Right now, they are appearing before the commission because, as the rule states, it says all felonies. So, but if an individual had a Class D felony related to theft of money, then that person would still be required to appear before the commission and obtain licensure.
I guess something that I haven't, been privy to, and I don't know if the other commissioners have, but how are the other professional commissions handling this fresh start? Are they, because I think we've kind of been more lenient because we keep hearing the fresh start program. Are they still being more stringent like previously, or were we previously more stringent, or have we always been kind of, on this fresh start program path? Or just, I'm sorry.
So the Fresh Start Act, the Fresh Start Act was enacted in July of 2018, and it applies to all occupational licensing programs across the board that are attached to the department. So any program or board or commission that had a rule that was more stringent than what is passed by the General Assembly had to amend their rules or statutes as such. So we're not the only commission that's having to do this, to amend those provisions, but others are doing this as well. It's a statewide statute, applies to, I believe, all of the professions listed in Title 62, which are the occupation, trades, and business commissions. Does that answer your question?
Yeah, it's better. Thank you.
Okay. Yes, Mr. Glenn. You're muted.
There we go. Sorry. My cursor was a long way away from my mute button. So I'm a little confused as well. Are we now determining in the hierarchy of felonies where the Fresh Start Act falls? Meaning, if we pass the rule, does the applicant coming to us exempted if they have a D or E felony? Is that incorrect?
So right now the rule is more stringent than the law. So we're amending the rule to match the law, which was passed by the General Assembly. So, for example, one of my jobs is if an individual is to apply for licensure, we look at their criminal history background. And if they have, for example, a misdemeanor charge that is unrelated to theft, money, or of services or property, that individual is allowed to proceed with licensure. So it's going to, instead, this rule is only going to impact individuals that have Class D or E felonies that are not related to the theft of money, services, or property, or any felony that is related to the Animal Abuse Registry or the Sex Offender Abuse Registry.
So does the Fresh Start Act specifically say in it what class felony you're talking about, or does it just say felony? Or I obviously should have read it, but what does it say?
So the Fresh Start Act includes, I can pull up a copy for you actually. So it lists the specific felonies that are provided. It's going to be typically, let me just read that information for you verbatim. Hold on one second.
Okay, thanks.
Okay, so the Fresh Start Act states for criminal convictions, if an applicant, licensee, certificate holder, or registrant's prior conviction was for a Class A felony, Class B felony, or Class C felony, not defined under Title 39 or Chapter 17, Part 4, or if the felony conviction is for an offense which the offender is required to register under the Tennessee Animal Abuser Registration Act, compiled in Title 40, Chapter 39, Part 1, the Tennessee Sexual Offender and Violent Sexual Offender Registration Verification Act, there shall be a rebuttable presumption that the conviction relates to the fitness of the applicant, licensee, certificate holder, or registrant engaged in the applicable occupation, profession, business, or trade. So the Fresh Start Act does delineate specific felonies and specific convictions that would require that have a rebuttable presumption that this conviction applies directly to the profession. So when we do, when an individual appears before the commission in a formal appearance capacity, that individual, if, for example, they are later, the commission decides not to proceed with licensure, we would have to go through the Fresh Start Act, which means we would have to make a determination on the face that the conviction applies to the occupation. And then there are 6 other factors that we would look at and have a discussion about. So those are the nature and seriousness of the crime, length of time, the relationship between the nature of the crime and the purposes of regulating occupation, relationship between the crime and ability and capacity to perform duties from the occupation, any evidence of rehabilitation or treatment undertaken by the individual, and then any applicable federal laws requiring an individual's participation in the profession. So as I was saying before, and I apologize if this is not clear, our rules are overly broad. So the rules have to be narrowed to match the law, the statute, which is superseding over our rules and statutes. For example, some of the other boards and commissions, when the Fresh Start Act was passed, a section of their statute was included in the area that talks about criminal convictions, stating that all of those convictions, any convictions or decisions made by the commission must be taken into account with the Fresh Start Act. So it's been around for about 3 years. I think we've only had 1 or 2 or 3 individuals that we've had to do the analysis with, but it's not very much off from the typical requirements of the commission. And I would like to be clear that even if an individual has a Class D or E felony related to theft, money, or services, or property or misdemeanors, the commission is still allowed to deny licensure to an individual. So you would just have to go through the extra steps to get all of the questions answered on the record with the factors. So it's just another discussion that we would have to have.
Okay, thank you very much. I guess I wonder if the legislature, so we're basically changing a rule to square with a law that was passed a couple of years ago. Is that what we're trying to do? Do you think the legislature knew that there were commissions that had rules that didn't align with the law that they were about to pass? And do they think, oh, we're just going to go fix that 2 years later, or they didn't care, or it doesn't really matter, I guess? Just because I'm wondering why are we changing it if we have provisions and methods to essentially square the Fresh Start Act with us anyway? See what I'm saying? Because we've been dealing with it for a couple of years.
Right. So I can't speak directly for the legislature regarding why the statute was promulgated. I don't know why that information is there. That would be another kind of question. But I do know that on rule and regulation, so in the hierarchy of different things, the law is always going to supersede any rule that the commission provides. So the law is enacted by the General Assembly, and the rules are enacted from the different boards and commissions. So law is always going to come first.
Got it. All right. That was a rhetorical question anyway, probably unnecessary.
Oh, sorry.
Thank you.
Yes, Mr. Begley.
So let's take, for example, the first case we heard today, the young man, and if we pass this law, or if we change this rule, if we change the rule would we have heard that case in 3 months from now, or would that case just kind of?
No, we still would have heard from him. The specific conviction that Mr. Cunningham had was a misdemeanor of burglary. It was a felony, and it still applies to B and E felonies that are related to theft of money, services, or property. So he still would have been required to appear before the commission.
Okay. And does this remove the 2-year section of our rule altogether? So if my probation, say I only had a drug charge and my probation ended 3 months ago, would I appear before the commission, or does it have to be 25 months ago?
You would appear before the commission. It removes the 2-year requirement.
So it does remove the 2-year requirement. So I could be off probation 3 months ago. My probation ended. I'd satisfied all my court requirements 3 months ago. It was only drug related, no theft, no child, no dogs, all that kind of stuff. So it's drug related. My probation and my court requirements were met 3 months ago. Would I still have to come to the commission, or would I not have to come to the commission?
You would still have to come before the commission because it's within the 10-year time frame. So our statutes allow us to look back 10 years. And if you have a conviction relating to theft of money, services, or property, that's a misdemeanor or a felony, you would be required to appear before the commission. But the 2-year requirement that you have to wait is removed.
Yeah, I'm saying that I didn't have any of the felonies that you're saying are applicable now. All I did was a drug charge. All I had was.
Then that individual would not be required to appear before the commission.
No matter if it was 25 months ago when my court stuff was done, or 3 months ago, correct?
That's correct.
Thank you. Sorry, everybody. I'm just trying to get clear on this.
Okay. Does anyone else have any other questions? Okay. So we have 2 more comments to read through. The next one is from Ms. Diane Farr. It states, I totally understand giving someone a fresh start, however, not when it comes to someone's money or personal assets. If you are convicted of fraud or of any felony or a misdemeanor involving theft of money, services, or property, you should not be handling the sale of someone's largest asset, their home. People lie. They lie all the time. Buyers lie. Sellers lie. Agents, even lenders, title companies, home inspectors, etc. But we should not be putting our clients in jeopardy with someone who has been convicted. I mean, what if they list a house with $500,000 worth of firearms and suddenly 2 go missing? Would they suspect the agent? Probably not, but they would if they knew or found out they had been convicted prior of theft. They should not have to disclose the information to potential customers and clients. I would not feel comfortable knowing there was a convicted felon trying to help me working for a home. My opinion. Previously, the commission did not have any comments to this, any response to this comment. Is there any response now? Okay. Seeing that there are none, I'll move to the last. The last comment is coming from Tennessee Realtors, Ms. Angela Shields, CEO. This letter is to serve as formal comment to the proposed change to TREC Rule 1260-01-0.01, removing the requirement that 2 years pass from the later date of expiration of probation, parole, or conviction, or release from incarceration for an individual is eligible to apply for a real estate license. Tennessee Realtors is in support of this rule change and recognizes that it will help offenders become productive members of society and reduce the rate of recidivism in Tennessee. Previously, the commission had no response to this comment. Is there any comment now? Okay. Seeing that there are none, Ms. Maxwell, or any written comments received? Oh, sorry, Ms. Franks.
I just want to be clear on this. If we do not pass this today, it's still, we have to go by the statute not our rule, even if we don't pass it today. Is that correct?
Yes.
Okay, that's all I need.
Mr. Diaz.
I just want to say, in general, I heard all the comments and I'm saved my comment for now. There's no possible way any of these commissioners could ever really know whether somebody coming before us has been reformed or if they're not going to be a recidivist. We rely on the brokers who are sponsoring these applicants to come forward to us to have vetted their candidates and to supervise them. So I think that is really the only check we have on these applicants when they come before us. And people are going to do what they're going to do. Our job is to protect the consumer as best we can. And I think this rule allows us to do that because applicants still have to come before us if they have a conviction that qualifies within the 10-year window. So I'm going to vote to support this rule, and I encourage other commissioners to do so.
Is there any further comments? Okay, Ms. Maxwell, or any written comments received by the Commission office regarding these rules?
No.
Seeing that there are no individuals, I'll ask one more time if we have anyone here present that would like to provide a comment to the rules. If you will place your name in the chat box in the bottom right-hand corner. Okay. All right, the comment period has concluded. Lastly, there are several measures I will need to adopt by motion and roll call vote as required by TCA Section 4-5-222. First is going to be the regulatory flexibility addendum. This states the proposed rule does not directly affect small businesses in the real estate industry. Specifically, the rules are designed to ease initial entry into the profession. Therefore, the impact, if any, would be positive impact on small businesses that are under the purview of the Tennessee Real Estate Commission. The proposed rules will require minimal, if any, costs for compliance. Furthermore, the proposed rules may have an impact on small businesses and consumers, but this impact is advantageous to both groups. Allowing more individuals to enter the profession may provide an increase in the amount of goods and services available to small businesses and consumers. An exemption of small business from these requirements would not be beneficial, as these proposed rules are designed to ease the entry restrictions for certain individuals impacted. Small businesses would benefit and not suffer any foreseeable detriment. If anything, the small businesses may benefit as the rule will allow for more individuals to enter the workforce. The Commission knows of no other less burdensome, less intrusive, or less costly alternative methods of achieving the purpose and objectives of the proposed rules. The proposed rules may be similar to other regulations within the department, as the Fresh Start Act impacts all regulatory boards attached to the department. I will now need a motion to adopt the regulatory flexibility addendum for amendments to Chapter 1260-01.
So moved.
Second.
We will now need a roll call vote to accept the regulatory flexibility addendum.
So if you're in favor of the motion, you'll vote aye when your name is called. If you're opposed, vote no. Caitlin?
Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Yes.
Commissioner DJ Ferris,
Aye.
Commissioner Marsha Frank,
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffitt,
Aye.
Commissioner Joan Smith,
Aye.
Chairman John Green.
Yes. All right, that motion passes. Anna?
Yes, thank you. Next, I will need to adopt the impact on local government statement pursuant to TCA Section 4-5-228. The statement reads, the Tennessee Real Estate Commission foresees no impact on any local governments. I will now need a motion to adopt the impact on local government statement for amendments to Chapter 1260-01.
So moved.
Move. Second.
All right, when your name is called, if you're in favor of that motion, please vote aye. If you're opposed, vote no. Ms. Maxwell.
Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Yes.
Commissioner DJ Ferris,
Yes.
Commissioner Marsha Franks,
Yes.
Commissioner Steve Glenn,
Yes.
Commissioner John Moffett,
Yes.
Commissioner Joan Smith,
Yes.
Chairman John.
Yes. So that motion passes. Ms. Matlock.
Thank you. And next, I will adopt the answers to the questions required by the Joint Government Operations Committee. I will now read these statements into the record. A, request a brief summary of the rule and description of all relevant changes and previous regulations effectuated by such rule. The statement says the proposed rules are in response to the enactment of the Fresh Start Act that became effective on July 1st, 2018. The rule removes the previous requirement that prevented individuals convicted of any felony or misdemeanor involving theft of money, services, or property from eligibility for examination or licensure unless 2 years from the date of expiration of probation, parole, or conviction, or the date of release from incarceration, whichever is later in time. Furthermore, the rule narrows the individuals required to appear before the Commission for licensure consideration due to a criminal conviction. Currently, the rule requires all individuals convicted of any felony to appear before the Commission. To comport with the Fresh Start Act, this requirement is narrowed to all felonies enumerated in Tennessee Code Annotated 62-76-104B4B and felonies involving the theft of money, services, or property. Pursuant to the Act, these felony classes have a rebuttable presumption that the conviction relates directly to the fitness of the applicant engaged in the applicable occupation, profession, business, or trade. Subsection B states a citation to and brief description of any federal or state regulation mandating promulgation of such rule or establishing guidelines relevant thereto. The statement reads, there are no known federal laws or regulations mandating promulgation. However, the proposed rules are required to comply with current state law, the Fresh Start Act, which went into effect on July 1st, 2018. The rule makes the necessary changes to align the rules of the Commission with the intent and requirements of the statute. Subsection C states an identification of persons, organizations, corporations, or government entities that are mostly directly affected by this rule and whether those entities would encourage adoption or rejection of the rule. The proposed rules would affect future licensees from the Fresh Start Act, is designed to specifically aid in their licensure process. The Commission does not foresee a particular segment of opponents for this rule other than licensees that may disagree. Subsection D states identification of any opinions of the Attorney General or judicial reading that directly relates to the rule or necessity to promulgate the rule. The statement reads, there is no known opinions of the Attorney General and reporter or any judicial rulings that directly relate to this rule. Subsection E states a probable increase or decrease in state and local government revenues and expenditures, if any, resulting from the promulgation of this rule and assumptions and reasoning upon which this estimate is based. An agency shall not state the fiscal impact is minimal if the fiscal impact is more than 2% of the agency's annual budget or $500,000, whichever is less. The statement reads, there is no foreseeable probable increase or decrease in state and local government revenues and expenditures resulting from promulgation of this rule. I will now need a motion to adopt the additional information for the Joint Government Operations Committee for amendments to Chapter 1260-01.
Move to approve.
Second.
Okay, you've heard the motion. When your name is called, if you're in favor of that motion, please vote aye. If you're opposed, vote no. Ms. Maxwell.
Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Yes.
Commissioner DJ Ferris, DJ, I think you might be on mute.
Yes.
Thank you. Commissioner Marsha Frank,
Yes.
Commissioner Steve Glenn,
Yes.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Yes.
Chairman John Curtis.
Yes. All right, Ms. Matlock, the motion passes. What do you have left?
Thank you. This now concludes the rulemaking hearing. Thank you. Following this hearing, the rules will be placed on the rulemaking filing form SS-7039 and submitted to the Attorney General's office for review and approval. Once the Attorney General's signature is obtained, these rules are filed with the Secretary of State and generally become effective 90 days from the date of filing. So that is all that I have for the rulemaking hearing. Thank you for your time.
So I think you should have estimated it would take about 45 minutes. That's what, you should take a chance on these things.
I'm not. I'm not going to do that.
All right, thank you, Anna. We're on to waiver requests. Caitlin?
Okay, before you, you have two waiver requests. The first of which is a medical waiver request for Lisa Wilson. Ms. Wilson has already renewed, so at this point she's asking for a refund of the late penalty due to medical circumstances. On the request, you will see an overview of her license and the circumstances. And if you have any questions, I can help answer those.
So to be clear, she's asking for $50.
That is correct, yes. And she has already paid and renewed her license, and so this one would be handled as a refund if approved by the commission.
Okay, commissioners.
Motion to approve this request.
Seconded by John Moffett. Discussion. If you're in favor of the motion, please vote aye. If you're opposed, vote no. If the motion passes, the state will refund $50. Caitlin?
Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Yes.
Commissioner DJ Ferris,
Yes.
Commissioner Marsha Frank,
Yes.
Commissioner Steve Glenn,
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Yes.
Chairman John Freeman.
Yes. Okay. That motion passes unanimously. We're on to Philip Burke. Caitlin?
So this one is a little bit different, but I thought it best to bring it before the commission. This licensee expired in March of 2020 and was affected at the beginning of April by the tornadoes. And he has asked for a waiver of the late fees. And since we didn't have any kind of executive order that particularly applied to this, I thought it best to just bring it before the commission. But this licensee reached out in December and is asking for a $900 waiver from the late fees. Marcia, do you have a question?
Yes, so he expired in March, and then April, the tornado hit his house. And then he was notified in December that his license had expired. I'm wondering, is this person they're an affiliate broker, right?
Yes.
So is $900 the total amount of his reinstatement?
Yes, we calculated that based on when he reached out.
And so, has he not been practicing any real estate since March of 2020?
Not that I'm aware of.
All right, and so he's saying he wasn't aware of it until December 2020?
That's correct.
Okay, that's all I have.
So the counter argument to that, Marcia, is that for 2 years before his license expired, he should have known when his license expired. And you've got, how soon can you renew your license, Caitlin, before its term is up? Months?
The renewal opens 90 days prior to expiration.
Hi, commissioners, what do you think?
Caitlin, when did his license expire?
His license expired on March 24th of 2020.
So he had since December, basically, to renew?
Yes, it would probably have opened on December 24th, give or take.
And the $900 is the accumulation of late fees beyond the rates?
Yes, the late fees are $50 a month for the first 120 days post expiration. And that basically starts the day after you expire. And then after 120 days, it is $100 a month up to a year.
Let's put something out there, commissioners. Let's see how it flies.
I'm gonna move to deny this request.
Is there a second? Motion is to deny the request and seconded by Ms. Smith. Now we can discuss it. Is there discussion? Marcia?
Has there been any discussion of, can he pay some of it? Is there any reason he couldn't pay a portion of it? Or?
What I have is actually what has been written in the letter. Is just that his life was turned upside down due to a tornado, and he needs assistance with the fees. That's essentially the gist of the communication that has happened with him.
So you haven't spoken on the telephone with him or had any person-to-person talk? It's all been in his written documents?
I have not had any in person. I do believe he has spoken with some members of the real estate staff.
So Marcia, we can do what we'd like to. If you're in the mood to offer a substitute motion that is something different than what Jeff offered, you've got the floor.
No, thanks.
Steve?
Curious, I'm trying to understand the logic of, okay, so the tornado hit a month after his license expired. So his excuse, or he's blaming it on the tornado that he's out $900. If we said, okay, we'll give you 3 months. So what would the number be reduced from to what? Like, can you see what I'm saying?
So,
in other words, so
for the first, oh, I'm sorry. I was just going to say the fee is $50 a month for the first 3 months, if that's what your question was.
well, I'm trying to, if you were, we calculated, in other words, he's built up 900 because it's so far out from April, right? So, or March. So if we said, all right, we'll give you three months of grace from the tornado, what the number would be, it would go from 900 down to what, 500? Maybe we say,
750. I think it'd go to 750.
750.
900 minus 150. 900 minus 150.
All right.
So it depends on if it's the first 3 months or the last 3 months. It's $50 for the first 120 days per month. So let's just say he had renewed in June, his fee would have been $225. But if you're saying take 3 months off of the end, then that would be $300 because it goes up to $100 a month after that 120-day period.
All right. So I think my proposal would be reduce from 900 to 600.
We're going to take that as a substitute motion. Is there a second to that substitute motion? John Moffitt seconds it. Okay, that's the motion on the floor. It'll take 5 votes to pass. If it does not get 5 votes, we'll go back to the original motion on the floor, which was to deny the request. Everybody clear on the framework? So the first vote, yes, Joan. Joan.
I'm trying. And that would have to be paid within 30 days. Is that correct?
Well, until it's paid, he can't get his license renewed.
Okay, but it continually adds up each month, correct? That's an ongoing expense. Is that correct, Caitlin?
That is correct. Up to 1 year, and once you're 1 year past expiration, it becomes a retest and reapply.
So if he agrees to this, then he's got to pay this within 30 days. Is that correct?
He's got to pay before March 24th. That's when his license will, is it revoked? Is it revocation?
It just becomes expired, and he has to it is expired, but it becomes to where he has to retest.
Okay, that's my question. Thank you.
Okay. As a reminder, the first vote we're going to take is to a motion to reduce delinquent fees to $600. If you're in favor of that, you'll vote yes. If you're opposed, you'll vote no. It'll take 5 votes to pass that. If he doesn't get 5 votes, we'll go to the initial motion, which was to deny the request for any relief. Everybody clear? All right. Your name is called. If you're in favor of the substitute motion, please vote aye. If you're opposed, vote no.
Okay, Commissioner Joe Begley.
Aye.
Commissioner Jeff Diaz.
No.
Commissioner Marcia Franks.
Aye.
Commissioner Steve Glenn.
Yes.
Commissioner John Moffitt.
Aye.
Commissioner Joan Smith.
Aye.
Chairman John Reed.
Oh. So that motion passes, I think, on a.
Oh, did I
DJ, yeah.
Yeah, I'll vote aye on that.
Okay. I'm sorry.
So that's 6-2 vote.
Yes.
So the motion passes. We're done with that item. All right, it's 25 minutes after the hour. Wherever you are, let's come back at 30 minutes after the hour. Take a quick break.
Degrees here, and it says it feels like -1.
Yeah,
Oh,
I've got thick socks on and I can still feel the cool, and I'm sitting here by my fire. So, yeah,
well, glad you're warm.
thank you.
Yeah, I heard something on a weather report I don't hear very often. The weather person said it was going to be a high of 1 degree. And I said
Wow.
that was overnight in Memphis.
Oh
At
my
least that's the
gosh.
report I heard. And I said, there's no way that a 1 is high.
Well, you guys in Memphis got some snow too, didn't you?
Yeah, we
Big
got
time.
about, depending on where you are, I guess we got about 5 to 7 inches.
Wow.
Hey.
John, it was 2 degrees this morning when on my thermometer on my roof, and Fairbanks was Alaska was 4. So we were lower than Fairbanks, Alaska.
Golly.
That's something to be proud of, Steve.
Yeah.
What about Joe Bailey in Upper East Tennessee? What's the temperature up there, Joe?
It's 68 and sunny. No, I don't even know. Let's see. It is 30 degrees and kind of a little bit of snow flurries, cloudy. 28 degrees.
John, it's 25 in Pigeon Forge. That's where I am.
I thought that looked like a hotel room, but I was afraid to ask you, Marcia.
We're stuck. We're stuck for a few days. And Brianna just told me that she's going to go see if the Dolly Parton, we're at the Dolly Parton Dreammore Resort, and she's going to go see if the Dolly Parton suite is available because there's only like 4 or 5 people even at this hotel at this point. We're supposed to leave today. Hector had winter break, but now we're stuck.
So you've been stuck there once before, right?
No, not. Oh, no, one time we had the flu up here. The last time we were here, we had flu and got stuck.
Yep, that's what I thought.
Now we can't go home.
Y'all might consider going someplace else.
Like Florida.
Like Captiva.
That's a good idea.
All right, ladies and gentlemen, let's get back to work here. We're to Ross White's report, education report. Mr. Director, what do you have for us?
Thank you, Mr. Chairman, members of the commission. Hope everybody is staying warm today and safe at home. I've got the February 2021 agenda, which you've, I believe, had the opportunity to peruse. I want to submit to you that I have reviewed the providers and the courses and the instructors for today's agenda, and I offer them for your approval. We'll start with the courses F1 through F24.
Your recommendation is to approve those courses.
Yes, sir, Mr. Chairman.
Is there such a motion?
Move to approve.
Ms. Franks moves to accept the Education Director's report. Mr. Bagley seconds the motion. Discussion. Anyone like a course pulled out? And since we're ready to vote, when your name is called, if you're in favor of the motion, vote aye. If you're opposed, please vote no. Ms. Maxwell.
You're muted, Caitlin.
Sorry, I've got the double mute. Commissioner Joe Begley,
Aye.
Commissioner Diaz,
Yes.
Commissioner Ferris, I might have lost DJ. Commissioner Franks,
Yes.
Commissioner Moffitt,
Aye.
Commissioner Smith,
Yes.
Chairman Grease.
Yes. All right, that motion passes. Mr. Quinn.
I vote yes.
Oh, I'm not doing a very good job with the roll today. I'm sorry about that.
You're doing a great job, Caitlin. Just some people's vote don't count as much as others, apparently. That's all I'm saying.
That's not true.
I know
I
it's
guess I'm
not.
having trouble reading today.
Just kidding. Mr. White, what about instructors?
Mr. Chairman, members of the commission, we have 2 new instructors in front of you today, and we ask for your approval for those 2.
Move to approve.
Seconded by Mr. Diaz. Ms. Franks makes the motion. Mr. Diaz seconds. The motion is to accept Education Director's report regarding approval of instructors. If you're in favor of his recommendation, vote yes. If you're opposed, vote no. Your name is called.
And even if your name is not called, please let me know.
I was going to say
Exactly.
that. I was going to say that, but I was afraid you might take it personally, so I chose not to.
No, when it's true, it can be taken personally.
Thank you.
Commissioner Begley,
Aye.
Commissioner Diaz,
Yes.
Commissioner Ferris, Commissioner Glenn,
Yes.
Commissioner Moffitt,
Yes.
Commissioner Smith,
Yes.
Commissioner Franks,
Yes.
Chairman Green.
That was a good catch on Ms. Franks.
Oh,
Ms. Marcia.
I wanted to ask, since we are on the education part, so I want to be clear about what the statute is on synchronous courses and Arello approval. I got a call from a friend in Williamson County, and she's an instructor. I wasn't aware that instructors actually have to form their own schools, or they have to be associated. I knew they had to be associated with a school, but there's some instructors who are just, getting started and having courses. So they've got to get an LLC or a corporation or something to open up a school to get a class approved by us. Is that correct, Mr. White?
Well, Commissioner Franks, no. Now instructors can stand alone. They are subject to an agreement with any of the providers they can teach with or for, but they can operate as their own business, but they have to have a provider that they work with in order to teach those courses. They can't just hold a course out and teach. Now, back to the synchronous question, there's nothing right now that other than if they're teaching an online internet course, which is asynchronous, those courses they would have to also possess a CDEI, Certificate for Distance and Education Instructor. So they would have to have that credential to be able to teach an internet asynchronous course. But we don't have anything in the rules yet. If, for instance, if we allow or later Arello, subject to the Arello certification for synchronous courses, that there be some other document or CDEI that an instructor would have to possess, because they're teaching a classroom course. We're approving a classroom course, and then subsequent to that, they're asking for a virtual approval or streaming approval, synchronous approval, but there's no other requirement now for the instructor to have.
So this person, actually, WCAR, the Williamson County Association of Realtors, they do not back instructors, and as many of the associations do. So this person from Williamson County would need to affiliate with another company and have the CDEI to do a synchronous course. Is that correct?
To do an asynchronous course, they would have to.
So synchronous, she would not have to, right?
That's correct.
Okay. Okay, because I know it's pretty expensive for just an instructor to open up a business, which you would have to do in the state of Tennessee. So I just want to get that clear. I'm trying to gather information from both you, Mr. White, and from Morello to see what we can do to lower the expenses for some of these teachers to get things approved, because I know it's a lot of money to them. So that's all.
I understand. Yes, ma'am. If
I'm looking
Philip,
forward to you being on those education certification committees too, Ross. So you're going to have the inside scoop on all that, and if anybody else is doing anything differently or better. So I appreciate
thank
it.
you. Thank you, Mr. Chairman. I'm looking forward to that as well.
Okay, thank you. That's all, Mr. Chairman.
Thank you, Marcia. Anything else, Ross?
Nothing else today, Mr. Chairman, members of the commission. Just stay safe and stay warm.
Thanks, Ross. We're on to the executive director's report. Ms. Maxwell.
Jeff, did you have a question? No. Okay. Well, I did want to just clarify really quickly, because Arillo has rolled out their synchronous course approval. Aside from the instructors, courses, we're giving courses and providers a couple months to get in line with that approval. And so I think we stated this last month, but starting in April, if you want to get a synchronous course approved, you would need the Arillo certification starting in April. And that's based on our statute. It's not really something that we can change without a statutory change. But as far as my report goes, I don't have too much of an update for the commission. I did want to let the commission know that we moved forward with the E&O suspension on 129, and roughly around 3,000 agents were suspended for a failure to maintain E&O. So those agents now have 30 days to get E&O without a penalty. And so starting on March 1st, anyone still without E&O would then become subject to the penalties that are laid out in law and rule. And then their principal broker would also be penalized after that 30 days. So the commission will probably start to see an uptick in complaints because once we get past the 30 days and we get into the penalties, the principal broker complaint is also opened against them. So I think you'll expect to see our complaint numbers rise from March forward based on those suspensions and penalties. Any questions for me?
Caitlin?
Yes.
Oh, Jeff.
Well, I guess I just wanted to ask, is just like maintaining the license, when it comes time for renewal, E&O insurance lands on the individual agent and the principal broker to monitor that, to know when it's up, to renew it when they're supposed to, correct?
Yes, that's on the individual broker, the individual agent. We do get a lot of questions because I know a lot of firms do a group policy, and that occasionally creates issues for us because based on our laws, we only require that the individual maintain their E&O insurance. We do not require that the firm maintain it. And so we need to know when those firm policies come in, we need to know exactly who is covered under that policy, and they need to be specifically listed. And we do, there's certain firms, it seems like we have trouble with every renewal cycle because there's kind of this confusion between the firm and the individual, but all that our law requires is that the individual maintain their E&O at all times. So if we don't know who's specifically covered, it can lead to some confusion. So.
Caitlin, anything else?
Joe, did you have a question?
Well, not about, well, I mean, since we're talking about that rule change today and just got through with the education and the E&O, so I don't know if it's appropriate or not, but at some point, you know, it's changing that rule is just another get into your real estate license. And I don't know, everybody's probably aware that Zillow purchased Showing Time last week. And, you know, I'm concerned, you know, I heard the statement about at one point and somebody said to make business easier to get into in Tennessee. But there's a lot of agents that if we don't start adding a lot of value to our services, then we just are adding fuel to the fire for, you know, online services. Because if it's really easy to get into and get licensed, and as far as state revenues, you know, we've got what 40,000 agents, and they're all making money. Whereas if half of those people got taken out by the internet type services, you know, all that money's just going to go to California, to Zillow corporate. So, you know, I don't know, not trying to make it harder, but at some point, I think we have to have discussions if we're looking out for the real estate industry about, you know, a little stricter, getting your license, getting your educations, you know, maybe some apprenticeships like auctioneers or appraisers do. I don't know the answer, but I mean, when does that conversation, or do we have that conversation, or is that for a different group, or what, Caitlin?
Oh, I would just say, you know, the commission's real mission is to protect the consumer. And so I think every lens that we look through has to be through the consumer lens and not necessarily the industry lens. I think the industry falls more to the association, and the commission is really responsible for consumer protection. So I would just say, you know, any company or individual doing something that falls under the Brokers Act would be required to be licensed. And so I do know some of those groups that you might be talking about are actually licensed. I'm sure there's always unlicensed activity, and we see that. And when industry members do see unlicensed activity, or when the public does, they should, you know, notify the commission through the complaint process and allow us to review it that way. So I don't know if that fully answers your question, but I would just say if somebody's doing something that falls under the Brokers Act, then they would still be required to be licensed.
Marcia.
Joe, also in the last week, I was contacted by the Arkansas Real Estate Commission. They had before their legislature, the Home Builders Association was trying to have them pass that a license was not be necessary on new home construction. And always in the past they've had that. Well, so when I got in this discussion with them about that, of course I was horrified, thinking that everybody needs to have a license to protect the public. But I did learn that there are some states that do not require a license for new home construction. To me and to the membership of Arello, we were very, very upset about that. So luckily, we came out with a white paper about a month ago at Arello, and it was all about why licensing is important and needed. And so we were able to give that to the Arkansas Association of Realtors, and they took that to the legislature, and that was defeated in the legislature. And that's not to say they can't come back and bring it again. But I will say that nationwide, it seems like it's mostly governors who are wanting to lighten the entry to professions. And on this commission, and I've been on it 6 years, I can see that both governors have been for that. And I think we have to really be careful with it because as Caitlin said, our biggest job here, and most important job, is that we protect the public. And, you know, the other side is, well, we need to protect the public by having professional people come in and get licenses in the state of Tennessee. So it's just a big ball of wax with a lot of plates in the air. We're talking about reciprocity with Kentucky and other places are coming once we open the door to Kentucky also. I'm liking where you're going, Joe, with this, because I think we need to have discussion about this because it's very important to, do we even have regulatory boards? I mean, it's gotten to that point. So it's a very important discussion, and I think it warrants us keeping a keen eye on the situation.
Thank you, Marcia. Caitlin, anything else?
Nothing else. I saw Jeff. Did you wave your hand?
Yeah.
Oh,
I
Jeff.
just wanted to add on, to Joe. I think one area that we can look at is also increasing the education standards for applicants. That might require a statutory fix with the legislature, which will be a long process. The rulemaking process itself is long, and getting the legislature to do something will be equally long, if not longer. But these are things that we need to explore. And I'd be open to that conversation at any point.
A couple of
I just want to know.
Go ahead.
I was just going to say, most of the actual education, like hours and those requirements, are actually set in statute. So it would probably have to be bigger than a rule.
A couple of years ago, there was a movement afoot in TR, Tennessee Realtors, to require more education. And that's where, I mean, we don't have lobbyists at TREC. So that's where it really needs to go, is to TR to carry that ball, because they do have lobbyists. And I think a lot of people are for more education, but a couple of years ago when it was brought up in their governmental affairs committee, they chose not to go forth with it. So, just talk to the people at TR to that's who we need to get to carry it, because we can't, which we're not allowed to do that.
Okay, Caitlin, one quick question. Marcia mentioned the reciprocity with Kentucky. Did the board in Kentucky sign the agreement?
They did. So that is now posted on our website and went into effect immediately following the signature. So I believe it officially went into effect on February 1st.
Thank you. And back to Joe for a second. This commission did that to benefit licensees. So we do advocate occasionally, but our primary focus, as Caitlin said, is the public, consumers. All right, anything else for Caitlin before we go to the legal report? Okay, so we may have set a new record for a number of cases on 1 month's legal report. However, it appears to me, Shalina, that you have found a way not to read into the record 126 case numbers. Would you explain what you've got in mind?
Yes, commissioners, I have included a document which in memo format, which lists the 126 cases for this month. And by the way, I apologize in advance. I did not intend for this legal report to be so long, but we have so many cases that we really need to move forward. So that's why it's this long, and hopefully in the next few months it will taper off. I expect that April might be a little large, but not nearly as large as this one. in any event, the document is a memo with all 126 cases, and I'm hoping that by motion, the commission will adopt that instead of me reading each one of those case numbers into the record.
So moved.
Second by Ms. Franks. Discussion on the motion. It's a brilliant concept, Shalina. Congratulations. We may argue with you about 100 of the 126 cases, but this is brilliant.
All I'm going to say, bless you, Shalina.
All right, the motion is to accept the cases as outlined in the attached memo. If you're in favor of that motion, please vote aye. If you're opposed, vote no when your name is called. Caitlin?
Commissioner Begley,
Aye.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Aye.
Commissioner Franks,
Aye.
Commissioner Gwynn,
Aye.
Commissioner Moffitt,
Aye.
Commissioner Smith,
Yes.
Chairman Grease.
Yes. Okay, with that said, out of that 126 cases, I've got a list of cases different commissioners have asked to be pulled for discussion. And I've got those cases from Grease, Diaz, and Franks. Does any commissioner whose name I didn't just mention have cases that you also would like pulled? Okay, so I'm going to state a motion that I hope I'll get I'm going to state a motion, hope somebody will make that motion and then second it. But the motion would be to accept council's recommendation for the cases listed in the February consent agenda, with the exception of the following cases: 17, 24, 25, 31, 32, 33, 34, 35, 37, 38, 42, 57, 68, 91, 98, 102, 103, 104, 111, 125, and 126. Is there such a motion? Marcia makes the motion. Is there a second? Seconded by Joan Smith. Is there discussion on the motion? This motion passes all cases we've just listed. Council's recommendation will be adopted. Then we'll discuss individually the balance. Any discussion? Let's vote. If you're in favor of the motion, please vote aye when your name is called.
Okay, Commissioner Begley,
Aye.
Commissioner Diaz, I think you said aye. Commissioner Ferris,
Aye. Yeah, this is Jeff. I vote aye.
Commissioner Franks,
Aye.
Commissioner Gwynn,
Aye.
Commissioner Moffitt, there's an aye from Commissioner Moffitt. Commissioner Smith,
Yes.
Aye.
Chairman Grease.
Yes. Okay, that motion passes. Let's give you a second. First one we're going to talk about individually is number 17.
Mr. Chairman?
Yes, sir.
I'm sorry to interrupt. I have been involved in reviewing the legal reports more frequently, and I'm going to ask that 126 be pulled because I would like to review that further and roll that to the next meeting if you would kindly allow me to do that.
So both Commissioner Franks and myself.
That was mine, Mr. Chairman. I'm going to pull it.
And mine as well. I absolutely, Mark, I'm all about you. We'll take it off the agenda, okay? But I'm all about hearing this case.
Right. I understand that. And before we discuss it, I want to review it. And I don't want to cloud any thoughts that I have and mesh that into what you are what your thoughts are. So I want to take it and review it one more time and at extremely ground level, and before we discuss it any further. That's what I would request.
Okay, so the chair will entertain a motion to defer case 126 to the March meeting. Second motion.
So moved.
Motion by Ms. Frank, second by Mr. Diaz. We'll have to call the roll to make this happen. If you're in favor of deferring 126, you'll vote yes. If you're opposed, you'll vote no. Caitlin?
Commissioner Begley,
Yes.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Yes.
Commissioner Franks,
Yes.
Commissioner Gwynn,
Yes.
Commissioner Moffitt,
Yes.
Commissioner Smith,
Yes.
Chairman Green.
Yes. All right, Mr. Green, what else would you like done today?
Mr. Chairman, I appreciate that, and what I'd like to take the opportunity when we reorganized how we manage the boards, and I just want to let you know that typically this board has been operationally supervised by a chief counsel. At the end of November, beginning of December, we decided that I would take over operational supervision of this commission, just because I'm familiar with it, and I thought it would be good for the legal staff to have me as the deputy general counsel be take direct supervision over TREC. So that's why I'm more involved in these versus other programs that I may not review everything, and so I wanted to let you know that's why I am more frequently present here lately, and that I am reviewing the legal reports prior to each month as a chief counsel would. So I just want to let you know that will be continuing to happen.
We're happy to have you monitor us.
I certainly don't look at it as monitoring you. I'm only here to assist and help.
But see, you cut your teeth with state government at the Real Estate Commission, so it's only appropriate.
You better believe I did.
I know you did.
In 2011, I was assigned it, and when I'm dead and gone, I think I'll still be answering questions about the Real Estate Commission. So, but anyway,
we're happy to have
I proved Wendell Alexander wrong. He said that when first meeting, Commissioner Alexander told me, he said, "Well, I guarantee you one thing, I'll outlast you."
Yeah.
Anyway, I'll shut up now.
Wendell was term limited. You're not. That's the difference, I think.
Yeah, that's right.
All right, thank you. Let's go to case number 17. This is one I asked the commission to take a look at. In my mind, this is a principal broker who represented a house to be 1,200 square feet, when in fact, apparently it was 1,536 square feet. at the last paragraph of the narrative, it talks about real estate agent provided all the necessary disclosures and advised the complainant to hire a licensed appraiser to determine the actual square footage of the property. There were no measurements taken by the real estate agent, and the real estate agent relied on the representation made by the sellers of the property. Well, to me, I think at the very least, there ought to be a cursory review of what they're selling. And I think square footage, maybe you can just, I'm not a residential agent, so I could be way off of this, but just putting a statement in there saying you figure it out yourself doesn't sound like the way you ought to do business. So that's why I pulled that one. Comments?
Chairman Grace, let me just clarify. The 1,536 square feet was the total square footage of the home, and the allegation is by the complainant that the actual livable square feet was 1,200. That was just the distinction that was made, and the respondent was merely saying that if you wanted to know the true actual square footage during the appraisal would be when that occurred. So there was a dispute as to the square footage, but it was a 1,536 square foot home.
Did it have an unfinished basement?
Yes, it was an unfinished walkout basement.
So is that square footage? Is that what the guys were?
No, that's not, you can't include unfinished space as square footage. So they said it was 1,500, but it was really only 1,200 because they included that unfinished basement, and you can't include that.
So Joe, what do you think?
Well, our MLS, I don't know, in the last few years, the way, I don't know if these online services or the MLS is adopted at first, but we used to only have finished square footage and then you would have basement and garage. Now it seems like they list this total square footage and then they break it down into finished and unfinished. But on a lot of our MLS and stuff now, it has that total square footage number, which is confusing for the public and sometimes for us too. But I don't know if that, my bigger thing was an unfinished walkout basement or a crawl space is two different things. I'm not sure how that is.
So do we need to move on from this case and take council's recommendation? Is there a motion?
I'll make a motion. I'll make a motion that we send a letter of warning because this is a principal broker involved here, that we send a letter of warning to this principal broker.
Joe Bagley seconds that motion. Discussion. Okay, if you're in favor of that motion, the letter of warning will speak to what?
To be careful about square footage. And I will say this, John, because you're commercial and I'm residential mainly, that we have disclaimers. TR even provides us a form of disclaimer where realtors really disclaim every involvement in anything pretty much. And that's being used on every contract that I'm seeing these days to protect the realtors. But on those MLSs, you'll also see it, and I would put it on there that you need to check it out for yourself too, because there have been so many problems on the square footage. And an appraiser is going to measure it different than I would measure it. I just think, since this is a principal broker, that a letter of warning would help this person to, let's be a little bit more careful about this, because maybe they won't get sued over the square footage, but they're having to come before TREC and they don't want to do that either.
Okay. Appreciate the input. If you're in favor of sending a letter of warning, requesting or suggesting that this principal broker focus on reasonable skill and care, you'll vote yes. If you're opposed, vote no when your name is called. Caitlin?
Okay, Commissioner Begley,
Yes.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Yeah, yes.
Commissioner Franks,
Yes.
Commissioner Quinn,
Yes.
Commissioner Moffitt,
Yes.
Commissioner Smith,
Yes.
Chairman Grease.
Yes. Okay, so that motion passes, and we're on to case 24. Jeff, you want to speak to that when I get to it here in just a second?
This one was the property that was on a lake and was represented that you were able to build a dock. You just needed to apply for a permit. It turns out that Corps of Engineers had allowed docks to be built on this particular tract of land for more than a decade. And I think it's the complainant who is filed this complaint against the selling agent, it seems like. Selena, I just wanted actually to clear that up as to who's who. So obviously the complainant is the purchaser of the property and the respondent is the broker who's selling the property.
Yes, sir.
Okay. Do we know if the complainant was represented by an agent?
I believe so, yes, the complainant was.
I think for me, we always have a debate as to where an agent's responsibility lies in terms of how much they know or don't know about a property and what a buyer may or may not be allowed to do once they purchase that property. I just don't know if this agent is responsible for knowing whether or not you can build a dock on Lakeside. I just don't know. To me, I would expect any commissioners have any thoughts about where that agent should be on that?
Let me say this, Marcia has also pulled this. So Marcia, you want to speak to it first, and then we'll go to DJ.
Yes. I would say this. We owned a property in Alabama that has a dock on it. If we had, and we were not represented by an agent, it was just the seller's agent. And so we wanted to be sure that there was a dock on it. And so we asked that they provide us that information from the Corps of Engineers, which they provided us. Now, so I'm thinking that I'm looking to both parties, the buyer and seller's agent. Somebody should have asked for some documentation on whether there can be a dock or not, because if you're a boater, put your boat at your dock, this is significant. So my reason I pulled it was because this is a principal broker. I hold them again, with more responsibility. And I pulled it because I think they should have the $1,000 civil penalty. And I wanted to add the principal broker core class to it because of this being a principal broker. But you're right, Jeff. But both realtors should, or both licensees should have checked on this any time, whether there was doubt or not.
Well, and it seems like the buyer made a specific request of their agent to make sure that they could build the dock. So it seems like it would let on the buyer's agent to document that and not just take the word of the seller's agent. It just seems like that to me.
DJ.
Yeah, thank you, Jeff and Marcia. I've had this one in my reading of the consent agenda, and the notes I said about this case was complainant agent ought to have advised regarding this. And so I didn't ask for it to be pulled. Hearing your remarks, Marcia, I think I do, because this is a principal broker. They've been licensed for so long. There is a higher standard I would expect from them. And I think I will vote in the affirmative of what the council recommended here. And if the respondent decides to come up and says, wait, let me tell you, here's what all I told them, and they can provide information that they did try to advise that this was, you needed to apply for the doc, and gave them, an idea that it probably wouldn't be adopted or whatever. Any more information that they can provide, maybe that'll change my opinion for their benefit. But I do, Jeff, I think the complainant's agent, I think there's as much or more duty on their part to help them discern and to know what can be done with this property. If the complainant was wanting to do a doc, their agent ought to have been able to say, we're not moving forward with this process until we've got that document in hand. I've been that complainant's agent before, not this particular one. I've been an agent for a buyer who was wanting on the lake. That's just what you do. That was the standard of care there. So that's all my remarks on that.
Joe. Hey, Marcia. What's the burden with getting in touch with the Army Corps of Engineers? Are they accessible, or is that navigating a bureaucracy?
That's not a difficult thing to do.
Joe.
Yeah, I don't know what the maximum penalty is, but the whole thing seems to me like that the agent for the seller was part owner of this property. His father, who is the other owner, is a licensed agent for 19 years in this area. And they're saying if they stated there could do a dock, I think they probably know that area. Surely to goodness, if I've been a realtor in an area around the lake, I know whether you can put a dock on it pretty much, unless it's just a circumstance that's weird. But then after they've told them that they could put a dock on it, and now they're saying they just didn't know, they go on down here and said that if it had been approved for a dock, it would have been over $200,000. So either they were selling it knowing it couldn't have a dock and they got an $80,000 discount, or they were selling it and saying there was a dock. It seems to be like two agents. You just can't push that off. I mean, two agents that's been in the business there for 19 years. I mean, I say smack them, with whatever you can.
Okay, so thank you, Joe. Marcia, did you want to offer an amendment to council's recommendation?
I'd like to make, I would like to add to council's recommendation that this principal broker also be required to take the principal broker core class within 180 days with no education going towards their required education.
Okay, is there a second to that motion? Thank you, Mr. Diaz. So I think the motion is in front of the commission at this point is to accept council's recommendation with the addition of a broker core class within 180 days.
Question.
Yes, Steve.
Make sure what the principal broker did wrong. What did they or he actually misrepresent? Because the way I'm reading it is that the transaction was not contingent on a dock. So what am I reading that wrong? I mean, what was the misrepresentation exactly?
Well, they stated, let's see, the listing did state a dock application would be applied for. However, it clearly stated there was no dock available. The seller stated that if there was a possibility of building a dock on the property, an additional $200,000 would be added to the price. You're right. It wasn't in the contract. It wasn't in the contract. If you're dealing in a lakefront property and the people are buying it for a dock, I think it's compelling that both the selling and buyer's agents would look into it for them.
But it did say before your ring, it said the sale of the property was contingent upon an appraisal, and the transaction was not contingent upon a dock being built or a dock application being submitted. So I don't, the way I'm looking at it is the buyer, the Pennsylvania person that's complaining, you know, was fully informed that I'm selling you the property with this. It's got no dock. If you want to go apply for it, fine, no problem. You may or may not get it. So I'm trying to understand what the person did wrong.
Commissioner, there wasn't the mention of the dock or the dock permit in the general information section, but there was a reference in the public remarks section stating that you could apply for the dock permit. So there was a reference to having the ability to get a dock.
Well, no, I mean, if it says you can, anybody that applies for something knows that it can go either way. I mean, just because you apply for a dock permit doesn't mean you're going to get it. I mean,
that's correct.
I mean, if I apply for a driver's license, I got to go pass a test. I may not get it. So there's no, at least the way I'm looking at it, there's nothing that this person did wrong that I can see based on the information written here.
So,
Steve, this is DJ. I'm seeing that again, and I'm reading it again closely, and I have a strong point.
I mean, it looks to me like that the buyer was trying to get a lot cheap with no dock permit, and hey, I'm going to go apply for a dock permit. If I get it, I made a good deal. If I didn't get it, I've made a bad deal. I don't want it. So tough. That's the way I'm.
So Steve, you've got every right at this point to make a substitute motion, which might be as simple as move to dismiss the case. That's what you said.
My motion, that because I had this one earmarked too, was my motion would be to dismiss the entire thing and not fine this person $1,000.
Okay, is there a second to that motion? Mr. Ferris seconds the motion. So we've got an original motion, which we will consider if the substitute motion fails. The substitute motion is to dismiss the case. It'll take 5 votes to dismiss the case. So if you're in favor of the substitute motion, your name is called, you vote aye. If you're opposed, you'll vote no. Now, is there any discussion before we vote? Jeff.
Steve, I see your point of view. I think another point of view might also be that at least if dock were possible on this property and he could apply, then I can see your point. But it seems like the Corps of Engineers just banned all docks in that property, and that seems like something the buyer could have been informed of before they finished the purchase.
You know, it's that's part of their due diligence. It should have been. I mean, before I spend, you know, if I'm banking on a dock, before I spend whatever the number is, I'm going to go check this out. It's going to take an hour or something. It's not a big deal. Go check it out. And just because you didn't check it out, sorry.
Hey, Steve.
And that kind of goes to the buyer's agent should have done the due diligence there.
Yeah, correct. Yeah.
Steve.
Yes,
so
sir.
The thing that I think was a little misleading was apply for the dock permit, blah, blah, blah. But being a real estate agent and having owned this as long as they had owned it, if they could have made an extra $80,000 with a $500 dock permit, you know, I mean, there's no way I'm leaving $79,500 on the table because I didn't walk over to Corps Engineer and get, you know what I'm saying? They're saying
maybe.
if it had a dock permit, it would be
You know what?
$200,000.
They also could have pressed for money and they said, you know what, I'd rather take 80 and not even have to go talk to the Corps of Engineers and move on down the road and not even worry about it. So,
So let's vote. Reasonable people can disagree on this one clearly.
Yeah.
Let's see how the vote turns out. If we're going to vote on the substitute motion first, offered by Mr. Gwynn, seconded by Mr. Ferris, which is to dismiss the case. If you're in favor of that motion, please vote aye. Your name is called. If you're opposed, vote no. Caitlin.
Commissioner Bagley,
Aye.
Commissioner Diaz,
No.
Commissioner Ferris,
Aye.
Commissioner Franks,
No.
Commissioner Gwynn,
aye.
Commissioner Moffett,
Aye.
Commissioner Smith,
Yes.
Chairman Grease.
No. So that motion passes. The case is dismissed, and we'll move on to case number 25.
Mr. Chairman, number 25 was one of mine. And what I'm looking for in this is that I see no response. I see no response from this person at all because they are unlicensed. Is that correct?
Commissioner Franks, no, we sent this to investigations and they did reach the respondent, and he explained that these were assignable contracts, and this respondent engaged this type of real estate and lived out of state. The main problem here was that there was not enough documentation or substantiation with the complaint for me to go forward and prove this case. That was the main issue, but the investigator did not find any unlicensed activity based on his investigation.
Okay, then I will move to accept council's recommendation and close this one.
Seconded by Mr. Diaz. If you're in favor of the motion, vote aye. When your name is called, if you're opposed, vote no. Caitlin.
Commissioner Bagley,
Aye.
Commissioner Diaz,
Aye.
Commissioner Ferris,
Aye.
Commissioner Franks,
Aye.
Commissioner Gwynn,
Aye.
Commissioner Moffett,
Aye.
Commissioner Smith,
Yes.
Chairman Grease.
Yes. All right, that motion passes. Let's go to number 31. Arcia.
Okay, this is another one where I don't see the respondent, who is the principal broker's response. Shalina, do you have a response from them?
I'm sorry, I'm having trouble with my cursor to unmute this. Yes, I do have a response. Let me just say number 31, 32, or number 31 through 38 are all interrelated. 31, 32, 33, and 34 are against the same respondent. It appears that the commission has kind of gotten embroiled in this filing of complaints against one another situation by affiliate brokers that have left the employment of the principal broker, And there's this back and forth of filing complaints, and some of them appear to be frivolous complaints as well. So I have responses for all of these. They sometimes are incomplete or do not make sense, but they're all interrelated, numbers 31 through 38.
So I have down no response on 31, 32, 33, 34, and 35. I don't have 36 down because it looked like a duplicate to me. It was the same wording totally on it. So you're saying you do have the response from the respondent?
No, ma'am, I've had the responses. Some of them were very short and were non-responsive to the actual complaint in terms of what the explanation was. But it was clear after reviewing all of these complaints that this was just a tactic being used by all concerned to file complaints against one another. Some of them appear to be frivolous complaints.
So what was the response on number 31?
I'll have to check.
And while you're doing that, that brings up a good, we need to have something that deters people from making frivolous complaints, because, you know, even a frivolous complaint.
I second that thought.
The worst thing is it takes up the attorney's time, and the commission has to pay for that. So, but I'm looking at and none of these were we giving a response. And I always look for a response because, you know, that can get the principal broker in a lot of trouble if there's no response. And if they're all the same case, then I have them for at least 5 no responses. That's just something that we need, regardless of what the response is, to know how to judge these.
Did you say 34 was a part of that also?
Yes.
But that's talking about the mortgage fraud.
Yes.
Okay.
But we didn't have a response on that one either.
Okay, this respondent said that there was a pending criminal investigation that was being conducted, and the respondent did not have the liberty to disclose any further information.
So is that
and they deny that any of these events occurred, and they're being painted in a fictional manner. So the responses are sometimes short and are incomplete.
But you're telling me that 31 through 35 all had a response from that principal broker, whether it's long or short. I'm just getting that response. Did they respond on each one of these?
Yes, ma'am.
Okay.
So maybe litigation monitoring is warranted here?
If it's in litigation, I think that we should. And so are you saying, go ahead, Joe.
So are you saying that each one of these people are filing frivolous complaints, or just one is filing continuous frivolous complaints?
I believe that they are all in some way filing frivolous complaints. Some of them might be legitimate, but I think this is a back and forth between parties, and practice happens to be involved because they're all real estate agents.
Bring them all to the board.
So it's multiple complainants. It's a different complainant in each one of these?
Yes, for the first 4, correct.
Okay, and so Shalina, did you verify that it is in litigation?
No, there is no litigation. She mentions this is a criminal investigation.
So do we know it's a criminal investigation? That we
No,
can
we don't.
put this off till we then monitor the outcome of that?
I wouldn't recommend that we put this in litigation monitoring because there's no evidence of any criminal investigation being conducted in this situation.
Yeah, I mean, it might not be a bad idea to let the court sort out the facts and then we can make a determination after that.
But if it's criminal, I mean, that's different than civil. If we were looking at civil, we could track it easier than if it was criminal. I mean, we didn't know if he might have been charged or not. That would tell us a lot if somebody had been charged.
Right. I would just like to chime in and say that if it is criminal and a conviction would stem from any charge, that person would be required to report back to the commission. And since we don't have an adjudication of guilt one way or another, I wouldn't recommend making a decision prior to letting that play out. So we usually don't do duplicative account of complaints, but in that case, it would not be duplicative because we would have new information that we do not have at this time.
So Anna, do you think it's okay to close them or should we defer them or what?
I think if you wanted to close them, we could. I think close and flag maybe might be the appropriate decision, but we won't know a final disposition on the criminal matter unless the respondent reaches out to us. So I think close and flag and probably an instruction to the complainant, if Shalene is okay with this, with the complainants to update us if there are any convictions charged stem from this.
So go ahead, Shalena.
I'm sorry. Let me just add that the complainant did give a rebuttal to the respondent's response and stated that there is not a criminal investigation. There was only a police report filed and no action was taken, and mentions that these are slanderous, false accusations.
So I'd like to make the motion that Anna just made so that we can close and flag and monitor this situation. That would be my on numbers 31 through 35.
Is there a second? Mr. Ferris seconds the motion. Shalena, are you comfortable with that motion? Okay, thanks.
Yes, sir.
Okay. Any further discussion? If this motion passes, cases 31 through 35 will be closed and flagged, which means at some point they could come back up under a set of circumstances that I can't visualize. Let's vote. Your name is called. Vote aye if you're in favor of the motion. If you're opposed, vote no.
Commissioner Begley,
Aye.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Aye.
Commissioner Frank,
Aye.
Commissioner Glenn,
Aye.
Commissioner Moffitt,
Aye.
Commissioner Smith,
Yes.
Chairman Grease.
Yes. That takes care of cases 31 through 35, now 37. Marcia and Shalena, this is still related, correct?
I'm sorry, I misspoke. 37 is not related. 37 and 30.
Okay, on 37, I think this complaint deserves a little discussion by this commission. The recommendation you'll see at the bottom is to close, lack of jurisdiction, and refer to the local real estate association to review the alleged ethical violation by the respondent. So most of you know, especially you who are members of NAR, that NAR has a new ethical requirement that anything that I say or do that is derogatory or inflammatory or in any way a person sees it as derogatory, then they can file an ethics complaint. And they're also telling the NAR associations to refer those ethics complaints to each of the real estate commissions in the United States. So this is why I want to discuss this, because in the past, we've never heard ethical complaints. And I think that it would behoove Tennessee, just so that the real estate associations would understand our position as to what is our position on this. Now, on the one hand, we are here to protect the public. But on the other hand, this is getting into, if I go to visit my Alabama family and somebody makes a derogatory comment, if I don't speak out against it, or if I were to smile or roll my eyes, that could be conceived as me agreeing with it, and charges could be brought against me ethically and before the real estate commission. In the past, we've not heard any ethical complaints. My question to this commission is, where do we want to go with this? Do we even want to be involved in this? Because I'll just tell you, my opinion is I think it's a huge overreach by NAR, number one, to have this, and number two, to be directing the associations to be filing complaints with the real estate commission. Because, I mean, get ready if we do, because we're going to see hundreds, if not thousands of these. Anybody that doesn't like another person could file this, because anybody can file, we all know that, ethics complaint or a complaint to TREC. So I would just like to say that I would be opposed to this recommendation, because I don't think we have jurisdiction to be turning ethical violations back to the local real estate associations. And so my motion would be to close this one, but I'd also like to hear from the other commissioners how they feel about this.
Marcia, first of all, is your motion to dismiss or to close?
Well, what's the difference?
But if you close and flag it, you know, it shows it could show up again. But your suggestion is to set a.
I'd say close it then.
And different attorneys think close and dismiss mean the same thing. But Mr. Diaz seconds the motion, which is to dismiss or close this case. Mr. Diaz.
The only thing I'll say is our authority is derived from the Broker Act, and the Broker Act doesn't give us jurisdiction when talking about the ethics of our agents. We just deal with their qualifications to hold a license. Their conduct is consistent with that outlined in the Broker Act and our rule. I would say that we shouldn't get into adjudicating the ethics of agents, and we should leave that to the real estate association.
Okay.
Mr. Chairman, this is Mark. May I just have a statement here?
You may.
I reviewed this case with Shalana. We were in agreement as far as the jurisdictional aspect. The troublesome thing to me, and I agree with Commissioner Franks, is NAR or the association, and we certainly know they establish ethical guidelines, is they aren't a governmental entity, whereas the commission is. And if you start down the road of sanctioning speech, you are going to open up a can of worms that and let out a genie that you will never get back in the bottle. And the government can't do that in any form, not the real estate commission. We can't recommend that we sanction speech, especially if it's not in the context of a real estate transaction. Now, if this is said during a real estate transaction, then you may have some professional conduct issues that certainly we could take a look at. But as far as expressing opinions, I don't think I agree. That is not a jurisdictional area that we have under First Amendment protections. Now, as far as referring it to the local association for review, we recommend that to give the complainant an avenue to have somebody that can look at it. And so that was why we made that recommendation to say, look, you're welcome to have the association take a look at this, and we'll refer it if you would like. Now, if you don't want us to refer it, but communicate with the complainant that would be the avenue in which they could take this matter to, we'd be happy to do that as well. So anyway, I just wanted to interject what we were thinking.
Okay, Mark, thanks for those comments. I have two quick thoughts. One, I don't need a trade association telling me what to do on this commission. And number two, we don't even know if this complaint belongs to that trade association, correct? And so the notion that we're going to refer it on to that particular agent's trade association may or may not be possible, because they might not be a realtor, for instance. So I'm in agreement with the motion that's on the floor, and I'm ready to get to voting unless there are other comments. Motion is to dismiss and or close. If you're in favor of that motion, when your name is called, vote aye. If you're opposed, vote no.
Commissioner Bagley,
Aye.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Aye.
Commissioner Frank,
Aye.
Commissioner Glenn,
Aye.
Commissioner Moffett,
Aye.
Commissioner Smith,
Aye.
Chairman Green.
Yes. That motion passes 1-38. Marcia?
On 38, I don't know, I didn't know what the recommendation is. Authorize a contested case, proceed and assess $1,000 civil penalty. And honestly, I'm up here in Pigeon Forge without my real estate law book. I forgot to bring that. And I'm wondering, this 621331A2, is that for failure to respond, or what is that for?
Yes, ma'am, that is failure to respond.
Okay, then I accept council's recommendation.
Is there a second? Mr. Diaz seconds. Discussion. When your name is called, if you're in favor of the motion to accept council's recommendation, you'll vote yes. If you're opposed, vote no. Caitlin?
Commissioner Bagley,
Yes.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Yes.
Commissioner Frank,
Yes.
Commissioner Glenn,
Yes.
Commissioner Moffett,
Yes.
Commissioner Smith,
Yes.
Chairman Green.
Yes. Okay, the motion passes. Commission, do you want to take about a 10-minute break and then we'll finish up when we get back? Let's say we come back at, let's make it 15 minutes, 1 or 5 minutes after the top of the hour. Okay, see you then.
Mr. Chairman?
Yes, sir.
Before you leave, I have to run to another meeting, but I'm going to ask Shalina and Anna if I'm needed to text me, and I'll be back. So if there's anything else that you need from me, I've got to get to this other meeting. But I anybody that needs to get in contact with me can through Shalina and Anna.
Thank you, Mark.
Thank you.
Judy still skiing?
She got back Sunday night.
Oh, looked like a great trip.
She always has a good trip. Okay, Jeff, when we get started, we're going to come back to you, case 42. Let's see. Okay, let's get this going. Case 42, Jeff.
So I'm going to make it real simple here. I've read it again before we came aboard. I'm going to go ahead and move to accept council's recommendation.
Is there a second? John Moffett seconds that motion. Discussion. If you're in favor of the motion to accept council's recommendation, you'll vote yes. If you're opposed, vote no. Caitlin?
Commissioner Begley?
Yes.
Commissioner Diaz?
Yes.
Commissioner Ferris?
Yes.
Commissioner Franks?
Yes.
Commissioner Glenn?
Yes.
Commissioner Moffett?
Yes.
Commissioner Smith?
Yes.
Chairman Grease?
Yes. Okay, on to case 57. Marcia?
On 57, I noticed that the recommendation was for $1,500 for failure to respond. And it's true we can only do $1,000, right?
Yes, Commissioner Franks, I'm sorry, that should be $1,000.
Okay, then I will make that substitute, not a substitute motion, but that I will make a motion that we authorize a contested case with a civil penalty of $1,000 on this case. And I would like that they take the principal broker core class 2, since it's a principal broker.
So I'm going to talk about this just for a second too. We had the agreed citation to the principal broker was for $500. Is that correct? The advertising violation.
Yes, that would be for the advertising violation, but this is for failure to respond.
I got it. But,
okay.
So this would be the second complaint. There's already one agreed citation out there for advertising. This would be a second, right?
No, sir, this is one and the same. The agreed citation was issued for the advertising violation, and there was no response, so to us open as a complaint.
I'm sorry, is this a separate complaint from the advertising violation?
No, it's not.
Then I think your recommendation of $1,500 at a minimum is okay, because we're rolling in the advertising violation proposal with this failure to communicate, a failure to respond.
But that was a previous citation, agreed citation.
That's what I'm trying to determine. We have two.
No.
So we issued a citation for the advertising violation, and they did not respond to that citation. So now our attorneys are coming back to us because they didn't respond. Is that correct?
Yes, ma'am.
So I get that. The question is, are there two agreed citations out there or just one?
Just one.
So the one can include both topics, the advertising violation and the failure to respond.
Correct.
That's why I think the $1,500 at a minimum is okay.
Yeah, yes, if we're calculating the failure to respond at 1,000 and the advertising violation at 500, yes.
So that previous citation no longer stands?
No, the agreed citation has now become a complaint. It's one and the same.
Okay, so so there's two. You cited just one in your recommendation, and it says and the advertising violation. Okay, I got it. So there's both of them. Both of them are there. Okay, now so that's my mistake then. So now we got to decide, is $500 enough from the advertising complaint? Is 500 what we agreed to the last time, the last citation?
Yes.
Okay, then I'll just say I move to accept council's recommendation with the addition of the principal broker core class taken within 180 days. And I will say to you, I've been worried, about this class. When's it going to be taught? This is a TREC class, so it's a part of the Tennessee Realtors Education Foundation now, and so they will be having that class. So I'm not as worried about the principal broker core class taking place. So I want to add that to that recommendation, if there's a second.
Selena, the reason I pulled this case was just to ask this question. Nothing irritates me more than a principal broker that ignores the real estate commission.
Mm-hmm.
So the advertising violation, we've got some latitude in a typical situation. But since it's gone to complaint status, can we amend that 500 to say 1,000 of the advertising violation? Is that already passed, that opportunity?
I don't believe you've taken a vote. Have you on this?
We haven't taken a vote. I didn't know if the 500 it's already set in stone, or can we go back and amend that since they didn't respond to the complaint?
Yes, you can.
So this is principal broker.
Are you cool with that? Anna, as our attorney, are you cool with us doing that?
Right, yes. So Shalina is right. If it was an offer before it was rejected, you can assess whatever you would like at this point.
Then I agree with you, John. And so should I make my motion then to be $1,000 for each of those, one for the advertising complaint and one for failure to respond, and in addition, the principal broker core class taken within 180 days.
I think it's an excellent motion. Is there a second? Second by Mr. Diaz. All right, discussion on the motion. If the motion passes, this principal broker will be offered the opportunity to pay $2,000 as a civil penalty, $1,000 as an advertising violation, $1,000 for failure to respond, plus take the principal broker's core class within 180 days, not to be counted toward any other required education. Any discussion? All right, if you're in favor of that motion, when your name is called, please vote aye. If you're opposed, vote no. Caitlin.
Commissioner Joe Begley,
Aye.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Yes.
Commissioner Frank,
Yes.
Commissioner Glenn,
Yeah, yes.
Commissioner Moffett,
Yes.
Commissioner Smith,
Yes.
Chairman Grease.
Yes. That motion passes. We're on to number 68. Marcia, you and I both pulled this one. Tell us what you think.
Well, I'm lacking information about that $300 gift card. And so I'm wondering, did they provide a copy of the advertisement when they filed their response so that we know that they provided all the required information along with that gift card?
Yes, ma'am, and I've reviewed that information with the rule, and it lines up. Everything that was required in the rule is within the advertisement.
So then I would ask, is this considered an inducement? And is that proper to offer $300 to someone to use them as their agent? It looks like an inducement to me. John, what do you think?
Well, what caused me to pull this is recently this commission voted and said that gift cards were the same as cash. We were pretty clear on that maybe 2 months ago or so. And so if that's the case, then is a $300 gift card the same as $300 in cash, which is expressly prohibited? That's why
It's up to me and you, John, that it would be cash.
I'd take it. So if it's cash, then I disagree with council's recommendation. If it's not a significant amount of cash, although it is to me, then I understand council's recommendation.
And I'm wondering where in the law is that one?
In the rule for gifts and prizes, it states that a licensee may offer a gift, prize, or other valuable consideration as an inducement to purchase.
That they may or may not.
That they may.
All right, and John, what was the one you were talking about? Where is that law? Do you know?
Well, there's a I can't quote it. Like you can offer a free competitive market analysis, but it can't be contingent on, you got to list your house for me to give it to you for free kind of thing. And I don't know if that's not under the prizes part. There's another section of the law that deals with that, I think. Anna, can you quote that 13302B?
About cash rebates.
Yes.
Yes, okay. A real estate licensee shall not give or pay cash rebates, cash gifts, or cash prizes in conjunction with any real estate transaction. As part of the Tennessee Real Estate Commission's general rulemaking authority, the commission may regulate practices of real estate licensees regarding gifts, prizes, or rebates that are not otherwise prohibited by law. And that particular citation is 6213-302B, and that is provided in the chat for you. Also, the rule citation is there as well. And if you want, you can get the page numbers in the green book. Hold on one second. Okay, and the green book, the statute is on page 27. and the rule for gifts and prizes on page 87. So 27 and 87.
So would you read the cash prizes once more?
Sure. A real estate licensee shall not give or pay cash rebates, cash gifts, or cash prizes in conjunction with any real estate transaction. As part of the Tennessee Real Estate Commission's general rulemaking authority, the Commission may regulate the practice of real estate licensees regarding gifts, prizes, or rebates that are not otherwise prohibited by law.
So that's on page 27. Is that statute or is that one of our rules?
That's a statute.
Okay. And to further talk about that, recently the Real Estate Commission said gift cards are the same as cash. We opined that, correct?
So I'd like to make a motion, Mr. Grease, that I'd like to make a motion that we assess a civil penalty of $1,000 to this affiliate broker.
Is there a second? Mr. Bagley seconds that motion. Jeff.
So, and I know the statute says no cash gifts or rebates in conjunction with a real estate transaction, but the rule says that they may if certain conditions are met. So in that hierarchy of that you explained earlier during rulemaking, the statute preempts the rule. So is our rule out of step with the statute, or are they separate, or do they stand alone?
They're supposed to be complementary, so hold on 1 second.
Chairman.
Okay, so the difference is that the statute talks about cash. It's talking about cash. The rule does not address cash. The rule talks about gift, prize, or other valuable consideration. So the rule and the statute are speaking to two different parts. That makes sense. The rule doesn't govern it. It doesn't rule out the rule. The rule does not permit cash, gifts, prizes, or valuable consideration.
Okay. So valuable consideration does not include cash, then?
No, it wouldn't, since cash is written in the statute. Otherwise, it would conflict.
Steve. 1 second, DJ.
I'm confused about the council recommendation. If I read the last sentence, it says the respondent has not violated the laws and rules of the Tennessee Real Estate Commission. So is that a wrong sentence? Is that an incorrect sentence?
No, if they are in line with offering a gift card, which is a gift card, then it would be in line with the rule. However, if the commission has determined that a gift card is cash, then there is a violation.
So the gift card exception would be part of the rules, not the laws. So in other words, this last sentence isn't up to date with the decision we made 2 months ago. Is that the way I'm understanding this?
Correct. If you have determined that gift cards are cash, then that last sentence is not correct.
Got it. Thank you.
DJ.
Thank you, Chairman. Is this a case where we opine that gift cards are the same as, and that changes the rule, or do we need to look to the General Assembly to change the statute to include gift cards on the side of that? Because as I'm following this at the moment, even though we have made that opinion that was sought from a mortgage broker, I think, attorney for a mortgage broker, I remember who that was. maybe it was a council, maybe it was somebody with CAR. I don't know. But that was just an opinion. And I feel like until that opinion is brought into a formal rule proceeding, or then we have to go with what not in violation to do.
Commissioner Ferris, I just like piggyback on that. I don't see it as an opinion. I see it as an interpretation of the statute by the commission. That's how you've chosen to read this particular statute. And that is within your purview to do so.
Yeah,
We have to be consistent on these things too. It's very important that we be consistent because of the last person, obviously. When we made the determination, we use that against them.
Yeah. Where I come down on it, I think where people get confused is that it's called a gift card. And gifts are allowed under the rule, but what you're giving them, in a sense, is cash, even though it's laying on a card. You're giving them $300, but you're not giving them 300, something that's worth $300, like a tangible item they're going to put on their desk. You give them a card to go out and spend, which they use as cash. But a person that's receiving the card is going to use it as cash.
Joe.
You know, this is an issue that we deal with as brokers and all the time. I mean, if the real estate commission can't figure it out, you know, these 36,000 other ones can't figure it out. So it needs to be black and white. Either you can give them stuff or you can't give them stuff. Because, I mean, for us to sit here and try to figure out if this is legal or not, then, you know, it's, I just think that it's not clear and it needs to be black or white. Either you can give gifts or you can't give gifts.
So maybe we need to make it clear in our rule.
Anna, you look like I'm way off base there, am I?
No, you're not way off base. I'm just trying to right now figure out if that would be a rule change or if that would have to be a statute change. I think it can be via rule, but I want to double check with Mark and I'll have an answer for you at the next meeting. Does that work? If that's the case, if it's rule, we'll just need to go through the rule process to get that amended, which Jeff is very excited about.
Yeah, and if it's not black and white, these agents are always pushing the boundaries and just testing the waters. And then we're over here spending 10 minutes trying to figure out if they've, you know, are in the gray area or the white area or the black area or whatever.
Right. And I understand that. And I think it's going to be kind of one of those things that we're going to constantly be updating. So like I'm imagining, so this statute was this was written in 1973 and then amended in 2007. So I don't really think that the contemplation of gift cards was really kind of there at that moment. So as we, you know, continue to find different ways to give money or those kinds of things, we're going to have to kind of update to modern practices. So it's probably going to be something we might want to discuss if we're doing a rule that's black and white, but does leave us some flexibility. Otherwise, we're going to be making rules every single time something else comes up. Does that make sense? Okay.
Yeah. Okay. I mean, you can get drawn into the conversation though about cryptocurrencies and all the other kind of stuff that's coming around.
Right, like Bitcoins. Yeah, that would be another discussion we would have. So I'll look at this. I'll talk to Mark and Caitlin, and I'll get an answer for you guys back next meeting.
I am currently taking Bitcoin, by the way.
So Anna, would you, as our attorney, suggest that we hold off on this one until next month and we have that, or how do you feel about it today?
Right, I don't think that you have to hold off on that. Like as I was mentioning to Greece before, the commission is allowed to interpret their statutes as they so choose. And at this time, the commission has decided to state that a gift card is considered cash. And so if that's the decision now, I don't find an issue with making that or waiting until a possible rule or statute change.
So then, Chairman Grease, I would like my motion to stand, please.
Your motion is to offer a $1,000 civil penalty for violating statute regarding cash rebates or cash payments. And we had a second on that motion. Was Joe, did you second that? Yeah. Okay. Discussion, further discussion. All right. If you're in favor of that motion, you'll vote aye. If you're opposed, you vote no when your name is called. Caitlin.
Commissioner Begley,
Aye.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Aye.
Commissioner Franks,
Aye.
Commissioner Gwynn,
Aye.
Commissioner Moffitt,
Aye.
Commissioner Smith,
Aye.
Chairman Grease.
Yes. All right. That motion passes. Let's go to number 91. Okay, so I pulled this case for a couple of reasons. But primarily because this appears to be a case where a real estate licensee, let me double check something real quick. Yes, this is where real estate licensee guaranteed if they couldn't, or guaranteed the home would be sold. So I just want to start with that. The home was never sold. And Shalina, did his guarantee say that he would buy it if it didn't sell?
No, sir.
So how did he guarantee the house would be sold?
Upon the actual sale. I mean, in this instance, though, what happened was there was an issue with the title company, and it was a mobile home. So the deal fell through.
I got that, but was part of his marketing that the house, he guaranteed the sale? That's kind of okay. So if he guaranteed the sale, did he have all the details of the guarantee included in that advertising?
I would have to go back to the actual wording of the advertisement.
As an example, you would think if he's going to guarantee the house would be sold, that a condition would be the title would have to be cleared, which in this case it wasn't. But I'm particularly focused on all these people, agents who are out there telling the public that they guarantee they'll sell their house or they'll buy it, or they'll buy their house within 6 days, or whatever the case may be, but they're not putting all the details as required by statute in the advertisement. So that's my focus on this particular case. Can you find that advertisement?
But what's interesting, Mr. Chairman, is that the agent couldn't buy the place either because it wouldn't clear title.
Yeah, but that had to be a condition. I mean, surely that's a condition of him buying it, or he would have bought it, perhaps. And all I'm saying is I want these people that are advertising, if I don't sell it, I'll buy it, to follow the law and put all the little details that go with it on the front, on the cover page.
I agree with the chairman.
Thank you, Joe.
So do I.
Thank you, Marcia. But let's see what the ad look like here.
Okay, I don't have the actual ad.
If we put this off a month, we could ask for it and take a look at it.
Sure.
That's good.
Move
So
to
it's a
defer
mo-
this case until next meeting.
Thank you, Mr. Diaz. Seconded by Ms. Franks. Discussion. All right, if you're in favor of putting this off for a month to get a little bit more information, vote aye. If you're opposed, vote no. Caitlin?
Commissioner Begley,
Aye.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Aye.
Commissioner Frank,
Aye.
Commissioner Gwen,
Aye.
Commissioner Moffett,
Aye.
Commissioner Smith,
Aye.
Chairman Grease.
Yes. All right, that's deferred for a month. Number 98 is our next case. Once again, it has to do with the dock issue, with the deeded dock on a lake. And council's recommendation is to close it because it's a contractual issue between the buyer and the seller. I think I could make the case that it's also a misrepresentation issue on the part of the agent. The way I read the case, it appeared to me that the agent said you could put a dock. And later that was found not to be true. So, Selena, what do you think about that?
According to the respondent here, what happened was this was after the closing of the home, meaning the issue concerning the dock occurred afterwards. And the dock belonged to another property owner, which became a community dock. And because the dock was owned by the other property owner who later learned of the issue with TVA, that's what happened to the community dock, meaning there was the community dock could no longer be used by the parties.
So,
there was a dock at the time of the sale, and there was the use of the dock, and the property owner had a dock. But then suddenly, TVA said to the person who owned the dock, the adjacent property owner, this dock is improper because of the frontage. Some of it falls on our land. So the dock has to be removed.
Which was after the property closed?
Yes.
So
at the time of purchase, it was advertised with the dock. The buyer had access to the dock after closing. And then TVA came in after that and said, this dock is improper, you can't use it, it's gotta go.
Yes.
all right, that answers my question. Is there a motion to dismiss?
So moved.
Second.
Motion by Ms. Frank, second by Mr. Diaz to accept council's recommendation and close. If you're in favor of the motion, vote aye when your name is called.
Commissioner Begley,
Aye.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Aye.
Commissioner Frank,
Aye.
Commissioner Gwen,
Yes.
Commissioner Moffett,
Aye.
Commissioner Smith,
Yes.
Chairman Grease.
Yes. All right, thank you. Let's move to 102. Marcia?
Okay, so this was a represent that we originally accepted council's recommendation for $1,000 civil penalty for failure to respond. And the new information tells all about cellar repairs and all of this other stuff. And it doesn't address the failure to respond. It only addresses the respondent is saying it was all these repairs and things going on, which to me has nothing to do with the failure to respond. They're responding after they got after there was a citation for failure to respond. So I'm not willing at this point to close this as per council's recommendation. And I would be in favor of us keeping the $1,000 civil penalty for failure to respond.
Let me just clarify. There was an affidavit provided in the response when this was followed up, and I was preparing this for hearing. The respondent contacted me through their attorney and stated that they actually never received the original complaint and were unable to respond because in the building that they're in, there's one receptionist that distributes the mail to multiple businesses in that building, and they never actually received it. So that's the main reason why there was no response. But as soon as they received my letter, they contacted me about this, and then they went into detail about what actually happened. So based on that reason and what actually happened, my recommendation was to close. I don't believe that this respondent caused the damage, but was willing to resolve the issue with the homeowner at the recommendation of their managing broker. So
this has nothing to do with that. This is only failure to respond. The damage to the property has nothing to do with that. It is up to the respondent, and actually maybe this goes to the principal broker, I'm not sure, but someone filed the green card that shows receipt of the complaint. Now, TREC is not responsible for how they do their mail. We only know that they had someone sign for it. What happens between the time it's signed and how it gets to them, I mean, anybody could use that as an excuse. I didn't receive it, or, you know, it got lost in the office. So it's their responsibility, not the Real Estate Commission's responsibility, to make sure that they respond to this. So I don't see that the fault lays with TREC, and they still didn't respond. So I don't know. Maybe you all have a different opinion on it.
Yeah, they had no idea they had anything that was requesting them to respond. As I'm reading this, that's correct.
So
it's their responsibility.
So Marcia, do you want to move to? We don't have to take any action on this, and the previous action stands. Or you could make a motion to confirm the previous action if that's what your belief is. You could die for lack of a motion. We move to the next case.
So I'd like to make a motion that the previous recommendation of $1,000 civil penalty for failure to respond stands.
Second.
Second by Mr. Boyan. Now discussion. Jeff. Then Shalina.
So I'll say there were two parts to our decision last time. We also had $1,000 civil penalty failure to exercise reasonable skill and care. Are we dropping that and just going with failure to respond?
Where are you reading that, Jeff? I just looked
It's
at
under
the
the
condition.
previous commission decision above new information.
No, I'm totally zoned in on the failure to respond unless you want to make an amendment to that.
Jeff, I interpreted her motion to drop the $1,000 exercise reasonable skill and care part and just go with 1,000 on failure to respond. That was my interpretation of my second on her motion.
And I will say this, I've overlooked that second penalty for failure to exercise reasonable skill and care. I'll let it stand at the $1,000 only.
Further discussion. Okay, DJ.
I just see in this that once the respondent was aware of this, it appears that they reached out to the commission promptly at that point, and they seem to be trying to do the right thing. And they've got two witnesses that can corroborate that the damage was not caused by any individual in attendance viewing the home. And I feel like they're trying to do the right thing. And the broker even said, "Hey, be generous and pay for half just to be nice," which is, I guess that could be interpreted as admitting guilt, but I don't see it as such. But I guess there needs to be maybe some type, we need to make sure our mail. I need to make sure I'm getting my mail. But now that we know more information from what we knew when we made the, I feel like they did exercise care, and my opinion would be the kind of $1,000 for failure to respond.
Other comments? Okay, the motion is to offer a civil penalty of $1,000 for failure to respond. If you're in favor of that motion, you'll vote yes when your name is called. If you're opposed, please vote no. Caitlin.
Commissioner Beckley,
Yes.
Commissioner Diaz,
Yes.
Commissioner Ferris,
No.
Commissioner Franks,
Yes.
Commissioner Gwynn,
Yes.
Commissioner Moffitt,
No.
Commissioner Smith,
Yes.
Chairman Grease.
Yes. All right, that motion passes. We're on to case 102. That was
103. 103, Mr. Chairman.
Okay, here's what I've got. It appears to me, Shalina, that because the parties have agreed to some sort of settlement between them, that you're recommending we go ahead and dismiss or close the case.
Yes, and sorry.
I was going to say, even though we had previously found or suggested that there had been substantial and willful misrepresentation and that the licensee had failed to respond on a timely basis and had misleading and untruthful advertising and had improper, fraudulent, or dishonest dealing. So I'm glad they settled, but I'm not in the mood to necessarily think just because they settled, all those things we thought that this licensing did should go away.
The main reason that I'm recommending this be closed is because when the complainant is no longer willing to cooperate with us, that poses a problem in terms of having a hearing. So if they are requesting this complaint be withdrawn, I'll have a great deal of difficulty bringing the hearing, but the only thing that I can say would stand possibly on its own is the misleading and untruthful advertising.
What about the failure to respond?
That also would stand. I was under the impression that they did provide a response.
So you'd be comfortable with a recommendation that offered a civil penalty of $2,000, one for advertising violation, one for failure to respond.
Yes.
All right, commissioners, anybody inclined to make that motion?
I'll make that motion.
Second by Jeff Diaz. Discussion. Okay, if you're in favor of the motion, which would, I guess we're offering this again. This isn't how do we think about this, Shalina? We're just modifying a previous recommendation, right?
Yes, you're modifying my new recommendation, correct?
Okay, and that modification would be to offer a $2,000 civil penalty, one for an advertising violation, one for failure to respond. That's the motion on the floor. Is there discussion? All right, if you're in favor of that motion, when your name is called, please vote aye. If you're opposed, vote no. Caitlin?
Commissioner Begley,
Aye.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Yes.
Commissioner Frank,
Aye.
Commissioner Glenn,
Aye.
Commissioner Moffett,
Aye.
Commissioner Smith,
Yes.
Chairman Green.
Yes. Okay. 104. Okay, Shalene, I think originally we suggested a $1,500 civil penalty. After additional information, you're now recommending a $1,000 civil penalty. Is that right?
I believe the total was 2,500. There was the $1,500 penalty for the statute, and then the $1,000 civil penalty for failure to respond.
And your suggestion now is to reduce it to just 1,000. And take some education. Is $1,000? What's it for?
The failure to respond.
Okay. Any discussion, commissioners? I take it, Shalene, there are extenuating circumstances that you found reasonable. That's why you're recommending a reduced civil penalty.
Yes, sir. And they have requested some leniency from the commission as a result of what happened with this father.
So Shalina, the previous decision was $4,000. Is that correct?
No, ma'am, it was 2,500.
Okay, 2,500. So now we're lowering it to 1,000. So the 1,500 that we are setting aside is for which violation?
For the trust account violations.
Man, those are big items, a trust account.
John, when you were reading these off, I had 104 and then 111 and then to 125. Did I miss anything? What number are we on?
Oh, 104.
Okay. I thought we went through that already. Okay.
So the trust violations were just matters of days, right, Shalina?
Yes, sir.
3 days, 5 days.
Well, that's not as significant then if it's 3 days or 5 days. It's not like it was 21 days to me. So maybe the, so we're at $1,000 right now in the new recommendation. Is that correct?
Yes.
Do we have a motion for that?
Looking for it.
I'll move to accept council's recommendation for $1,000 penalty and require the respondent to take continuing education course for trust account management.
Seconded by Jones Smith. Discussion. If you're in favor of the motion, vote aye when your name is called.
Commissioner Begley,
Aye.
Commissioner Diaz,
Yes.
Commissioner Harris,
Aye.
did I get Commissioner Ferris?
Oh,
No.
No, okay. I had an aye from Commissioner Frank. Commissioner Gwynn,
Aye.
Commissioner Moffitt,
Aye.
Commissioner Smith,
Aye.
Chairman Grace.
Yes. That motion passes. Thank you, Shalina.
You're
And-
welcome.
And you get the most valuable trophy today, too, for that little exhibit that had all the case numbers pre-printed. Good job.
Well, thank you. I hope I made up for any other
No, you did
issues.
fine. It's great strategy. So, Pamela, have you ever been here before? Can't hear you, Pamela. Can't hear you.
Yes, I've sat in on some meetings. I think Pam Spicer introduced me back in maybe in November's meeting, but this is my first time presenting any cases to you all. So, hello.
You're getting off pretty easy, it looks like to me, but we are going to go to one of your cases, case 111.
Yes.
Mr. Diaz.
Yeah, the one question I did have, I understand that they went through and worked with Google AdWords and all that kind of stuff, but their original ad was still in violation of our ad rule, correct?
Yes. And unbeknownst to them, they had hired an advertising company that a lot of Tennessee brokerages use, and it was the advertising company that had certain search terms that it set up for each particular market, and it just so happened that the search terms that they used for this firm in particular drove some Google traffic to them. And so it wasn't customizable. It was just something that was set up. So once they received the original complaint, which I believe was against the firm, they went to the advertising company and had them do whatever they needed to do to fix that, correct that. They did. That was taken care of last summer. So when the complaint was opened against the broker went back again and checked with the advertising company and got another letter saying that all of those issues have been resolved.
So was the ad in question something that the broker approved before it went out, or is this something that just went out automatically by Google?
Went automatically by pursuant to the advertising company, the program, the Google AdWords that were actually used to create the search program.
So the broker didn't see it before it went live; it just went out.
Right. They just chose. The broker says that the advertising company was made aware of all the advertising rules and so forth, even though ultimately it's the broker's responsibility, of course, but that they use their own metrics for each particular market. So it wasn't a situation in which the broker had gone and selected AdWords or gone through that necessarily didn't realize that would end up driving traffic from from any other websites.
Okay, so I get what I'm trying to get at is this ad that is in question was not approved by the broker before it went out, and the broker did not see it. It was just an automatic process that went out.
It's my understanding from the complaint, it's a matter of ad words. And no, it went out, it was created by the advertising company, if I understand your question.
Right, created by, I understand that, but not at the request of the broker. It was just something that went out.
Correct.
Okay.
So, Mr. Diaz, don't you think it's important that a principal broker not usurp their responsibility to an ad company? I would want approval of anything that went out advertising.
Well, yeah, I would think so. I would think that a broker, a principal broker, especially one that has a history of coming before this board, would have been extra vigilant about the ads that are going out in their name. But if it's just an automatic process that an algorithm spit out that nobody actually pressed a button on, I don't know how we can hold the broker really responsible for something that was done without their knowledge.
So I would like to know about this principal broker's history. In 2011 and 2017, they had civil penalty consent orders. Did they have to do with advertising?
Not directly. The 2017 consent order pertained to a situation where they had an assistant working for the firm who had posted on her Facebook page a rental property that the firm had listed, and so there was a consent order where the broker had agreed to $1,000 penalty for the violation would have been employing somebody who was engaging in unlicensed activity. The assistant took it down once she was educated. She couldn't do that. And then in 2011, I wasn't able to find out details about this because apparently that is still, those records are not accessible, or they would have to be taken out of storage. But I was able to determine that that was a penalty for having an affiliate who had an E&O insurance lapse.
Joe. So just to speak a little bit on Google AdWords. So I don't know if Marsha or Jeff, if you've ever used it yourself, like manually, not hired somebody, but used it. So it's not the ad that said their name. It's the words to get there. So it's like Coke. If you look up Coca-Cola on Google, Pepsi and Dr. Pepper and Mountain Dew is going to show up. Like one of my AdWords would say Remax, Coldwell Banker, whatever, Century 21. So I'm just driving traffic that pops up as that little ad. I'm not sure that's even illegal for they didn't say the other firm's name in the ad, did they? It was just when the page popped up, when you typed in Joe Begley Real Estate, it might have popped up Jeff Diaz, an ad right there, right? Is that what I'm hearing or not?
That's correct. That's exactly
legal
right.
to use an ad word with another firm? That was my question.
Well, my understanding, the situation in this one is that it just so happened that the AdWords that they put in weren't associated with the other firm. It just happened to drive the traffic from the way it was constructed with the advertising company.
And the reason I ask that is because I've done it. And even on Facebook advertising, when I place a new home, my, I don't know what you call them, associated words or whatever, I put home and garden and that Chip and Joanne and all these people that are interested in real estate type stuff.
Yeah.
That want to see my new construction type stuff. So, I'm interested to hear this is a whole another can of worms because, I'm typing in stuff that's going to draw people we're already friends of or following of or whatever to try to get them to my page too.
Mr. Chairman.
Oh, Steve.
Question. Maybe Pam, you could explain the sentence I'm going to read. It's kind of midway down the paragraph, and I'm trying to understand the complainant may be a real estate firm. It says the advertising service also indicated it would revise the query to make sure the complainant's name is removed when a query is made, and it would purposely exclude the complainant's name so that respondent's website does not appear in lieu of the complainant. What in the world does that sentence mean exactly?
Well, that sentence was actually from the 2020 meeting from the original complaint. That was the way the principal broker had explained that. The advertising service explained it, and I apologize. I'm not up on the advertising and Google searches and the algorithms. So,
it sounds like the complainant was complaining that when he or she had to do a search, that the respondent's name came up, and that information got the respondents, and that person that was complaining did not be identified as a person that was searching. Am I reading that wrong, or I'm totally? In other words, it says that the complainant's name is removed when a query is made. That means a search, right? And it would purposely exclude the complainant's name so that respondents does not appear in lieu of the complainant's firm. I know we're getting into the weeds on this, and it's kind of late in the day or late in our meeting, but I'm really puzzled by what that sentence means and what the problem is actually.
So the way I understood that sentence, Steve, is that whenever the query was entered and the respondent's name was going to be part of the results, the complainant's firm would be removed, excluded from those search results purposefully, not entirely from the universe, but just from the search results that include the respondent's firm.
The search results that include the respondent's firm. Do you think the complainant is a real estate firm, or what kind of group is the complainant?
Regardless, they don't want to show up on the search results.
Right.
So as part of the query, yeah, as part of the query construction, you can include results, but you can also exclude results. So when someone Google AdWords is saying include all of this stuff, they can say, well, but exclude this aspect of it.
It's like the name of my company is Franklin Realtors. And so you put in Franklin or you put in Realtors and mine comes up, and maybe they don't want mine to come up.
Right. But that's part of the deal. I mean, that's life.
Hey, Steve.
Yes.
So if you'll tell me how you're going to vote, I'm going to vote with you. You just go ahead and vote. Whatever you vote, I will vote with you. Okay?
Who pulled this one?
This is a Jeff.
Yeah.
Your motion. What is your motion, Jeff?
To recommendation.
Is there a second?
Second.
So you've got 3 votes so far. Okay. Any discussion? If you're in favor of accepting council's recommendation, you'll vote yes when your name is called. If you're opposed, vote no. Caitlin.
Commissioner Begley,
Yes.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Yes.
Commissioner Frank,
Yes.
Commissioner Glenn,
Yes.
Commissioner Moffett,
Yes.
Commissioner Smith,
Yes.
Commissioner Grease. Chairman
Yes.
Grease.
Okay, that motion passes. We're on 125. And here we have a situation where I agree with council's recommendation. But we also have a principal broker who doesn't believe that his firm did anything wrong. So I think in this case, it would be appropriate to accept council's recommendation, but add to it that the principal broker take that principal broker core class that Ms. Franks likes to throw out there. I think it would work on this one. So those are my comments. Is there such a motion?
So moved.
Second.
The motion on the floor is to offer this civil penalty of $1,000 that require the principal broker to take the principal broker's core class within 6 months with the standard strings attached. Discussion. All right, your name is called. If you favor the motion, vote yes. If you oppose, vote no. Caitlin.
Commissioner Begley,
Aye.
Commissioner Diaz,
Yes.
Commissioner Ferris, I think you're on mute. Commissioner Frank,
Yes.
Commissioner Glenn,
Yes.
Commissioner Moffitt,
Yes.
Commissioner Smith,
Yes.
Chairman Grease.
Yes. That motion passes unanimously. Ms. Fodder, anything else for us?
I'm sorry.
Is that all you've got for us today?
That's all I have for you.
Congratulations. Thanks for your report. Shalane, anything else from you?
No, sir, that's all. That's all I have.
Okay, one more attorney to ask. Ms. Matlock? Anything new, anything for us?
Yes, actually, I think, or maybe, okay, you don't have to, unless we want to talk about it at the next meeting. Just wanted to briefly go over the Attorney General opinion that we received.
Go ahead.
Okay, so we put in a request for an Attorney General opinion specifically for 6213-312B11, which allows for any person, which states any person or entity other than an affiliate broker who is affiliated with the licensed principal broker to disperse a commission or any valuable consideration. So we sent the question to ask if this states that the principal broker must be the entity to disperse a commission or any valuable consideration. And the second question was, does an agency relationship created by 6213-401 or by common contractual law allow for a licensed principal broker to contractually delegate their duty to disperse a commission or any valuable consideration? So the Attorney General's office replied yes to both of those questions. So that means the statutes does not prohibit a licensed principal broker from delegating to a company such as a title company or another third party the authority to disperse commissions or any valuable consideration. That can be contractually delegated, stating in your contract you can allow for someone else to take the lead on that. But it does not absolve the principal broker of responsibility from any actions that may occur from the disbursement of funds. So if there is an issue with a fund with money that has been delegated to a title company, the principal broker is still going to be responsible for that. It's not contracted away with that delegation. So that's basically the gist of it. Does anyone have any questions?
Jeff?
I guess, so does a contractual relationship with the title company need to exist for them to allow the title company to disperse the funds?
And a principal broker is permitted to enter into a contractual relationship with another entity, such as a title company. It's not required, but it's permitted.
Not required. So, I mean, because the title company has no obligation to handle those funds, and they have no accountability to us in terms of handling those funds.
So this is only for people that want to do that as a business practice. So it's not going to impact the principal brokers that still disperse commissions on their own. So if Jeff Diaz wanted to make a decision that Anna Matlock Title Company is going to disperse your commissions, then you're allowed to do that in contract. But if Anna Matlock Title Company has any issue with the commission because of any issues such as they lose the commission or doesn't give the commission back, then Jeff Diaz is still going to be responsible for that.
Okay, so, and then that'd be adjudicated by the commission against the principal broker.
Right, so it would be that the person would, if there was a complaint, it would be open against the principal broker, and the commission can make that determination.
Okay.
Hey,
Well,
Jeff.
that's wrong with your title company, folks.
Jeff, and it sounds like they're talking more about commission than escrow checks.
Right, so that B11 is specifically for commissions or other valuable consideration.
The Keller Williams lady today acted like they didn't handle their own escrow checks.
Right, you're not required to. There's a waiver. So if you enter into an escrow waiver, that is permitted under the laws and statutes. I mean, the laws and rules, same thing.
Okay, Anna, just a couple quick thoughts.
Mm-hmm.
The letter requesting the opinion was brilliantly composed. We've talked about that before. And even Mark Green said you wrote that letter.
Yes.
Even though he signed it, but congratulations on that. Number two, more importantly, the Attorney General saw this was such an important opinion, he made it his first opinion of 2021, right?
Yes, or it maybe was a timing thing, but I'll go with your answer if you want me to.
No, it's the most important thing he had on his desk, and so he tackled the most important first in 2021. So congratulations.
I just think it was a low-hanging fruit.
Oh, no. All right, Caitlin, what else do you have for us?
I don't have anything else. Just thank you all for bearing with us with the weather. I think we both decided it's probably not the best idea to have a meeting right after a holiday. But thank you all, and I hope you guys stay safe and warm, especially if you're Middle Tennessee West.
So let me go to Anna. One more question. Next month.
Yes.
Formal hearing.
I do not have a formal hearing next month. I'm not sure about Shalina, Pam, or possibly another attorney. So I think right now we do not have a formal hearing scheduled for March.
It's not going to happen because Joe Bagley has just waved it off. Okay, so we don't have one. And the last thing I need to ask is Joan Smith about this ice and this freezing. What about the strawberries? Is the festival still going to be okay?
Festival is on. Right now, we're going to have a festival first full week in May. And I hope you're all here.
Well, we're supposed to be somewhere west. I hope we're together.
I do too. Yes.
All right.
And let me
everybody go get your king cake. It's Mardi Gras.
Oh, that's true. Let me also say, Selena, I meant to count of the 126 that we had this time. Do you know how many of those related to timeshare? I was going to count those because it really concerned me this time. It seemed like
23.
they were awful. How many, Jay?
23.
There were 23 of them that were timeshare.
That's how many I counted.
Okay. Just seemed like there were more than that.
Beginning next month, I plan on separating out the timeshare cases. That way it'll be easier. They'll be grouped together under both either myself and Pam, or whoever has them. There'll be a section for timeshare cases.
Thank you. Thank you for doing that. I appreciate it. Thank you.
And do we have the timeshare videos up on the TREC website now, Caitlin? Because that's going to help a lot of people to understand about complaints.
So I have pulled out some points from the videos and sent those to our communications team so that they can share the videos, but then also just highlight if you just have a minute to quickly read through just the tips. So I need to follow up on where they're at with that. There's also a blog post that I have gotten a draft of while we were in the meeting specifically on timeshares that the communications team plans to share, kind of like we did with the buying a home. So it's also in that. I'm sorry, I got another note about we did release a newsletter. I don't know if you guys received it. It was supposed to go out last week.
No, I didn't receive it.
No. You didn't receive it. Okay.
Caitlin, I'll
we
follow
also
up with you
on highlighting those things, highlighting the timeshare concerns there as well.
Thank you, Caitlin. Steve, anything you want to say on the way out?
I don't know if this is maybe a follow-up on something Joe mentioned a couple of hours ago about how to work on frivolous cases. Maybe that's something we put on our to-do list to discuss, or if there is anything that we can do there. I think it was a good thought, and we ought to follow back up on it.
Thank you. DJ?
Thank you, Chairman. I am good. Great to see you all. I'm going to go play in the snow with my children.
Have fun. Jeff? Joan? Joe?
I'll just say I'm ready to get back in person. Missing seeing all you guys, and these Zooms are tough.
I hate them. Okay, Marcia, what do you have?
The only thing I wanted to tell you is there is some news from Morello about our mid-year meeting. It was postponed, and it is now set. It's going to be a hybrid, so we're going to have in-person and electronic June 29th through July 3rd at the Omni Hotel in San Antonio, Texas. So I'd love to see some of our realtors make that meeting. And I know some of our staff are on some committees, so we're looking forward to it.
Thank you. And John Moffitt, do you really want to meet in person, or do you just like being in Florida calling in?
Well, I'd love to meet in person, but it's a lot more fun than Zoom. But I'm going to go to the pool in a few minutes, so hope you all have a good rest of the week.
You too, John. Thanks for participating. And thanks to all of you and your commitment to the great people of the state of Tennessee. You're doing good work. Have a great week.
Thank you, John.